Ma'am, I am audible?
Page wise mentions amma. Out of list kuda untada. First page wise mentions. First time page wise mentions. Page wise mentions. Then page wise. Pass on. మధ్యాహ్నం 2:20 వచ్చేది వీడు మధ్యాహ్నం Correct. పోయిందా మీ పట్ట అన్నట్టు కదా వేరే పని పోయిందా అంటే ఈ ఇంట్లో కాకుండా ఇంకో చోటు ఉందా సరే ఇదా ఎందులో వాటర్ ఇప్పుడు పోసి పెట్టకూడదా Yes. Yes.
Silence.
May I start? Place by mentions. Page number 1. Motion please. Page number 2. Page number 1 to 8. Page number 2, 9 to 22. Page number 3, 23 to 41.
36 years. 36.
You appeared for the petitioner? Of the council for the petitioner. List next week.
With your permission, my lords, item 30, my lords.
Not 14. Yes.
Item 30, my lords.
Yes.
My lords, I'm requesting this matter for Tuesday. I have to file the counter to the IA, my lords. I'm receiving the counter today evening from NMC, my lords. I'll file it tomorrow, my lords. Requesting this matter to be posted to Tuesday for final hearing, my lords. Monday being a holiday.
14.
Your Lordship, I would like to pose the mentioning matter is listed on as item 30 today. Let my senior come. We can decide this issue. We filed an IA, but otherwise, overall the matter, the pleadings are complete in the matter. You given her time till 6. She took time till 9. This is her 7th or 8th adjournment. There is
My
absolutely
lords, I have let them not make such irresponsible statements. I have taken a week's time to file the counter, and
Sure.
I am, my lords, I'm getting.
explain once the matter is called out. She can then explain her side why she is not been able to file the counter. Let the matter be called out as
Because
item.
they are the ones when the matter is posted for final hearing, they come up with an IA, my lords.
I'll do one
With
thing.
all due respect.
I'll hear them today. I'll hear you on 14th. Yes.
Very well, my lords. If we can do it. Very well, my lords.
Yes. Item 24. Yes. Who expired? The petitioner just after 2 weeks. This one. 23rd November. Yes. Page number 4, 42 to 50. Yes, they request. I'll say 21st. Yes. List on 21st. For the purpose of filing reply to the council request. The request of the council for the petitioner. Yes.
It's a permission, but we can ensure this matter. This is the second round of litigation. The first round of litigation is direction to allot the data to this petitioners. but they did not allow. We are in the second round of litigation that is pending. They are going to conduct interviews tomorrow, my lords. Therefore, I am already informed the other side.
Yes, 2:30. Yes, tomorrow. Yes, list on 15th. One second. I said 15th for that. Put up. 15th. Yes.
The last adjournment, was directed to finish the matter today, but the matter was not listed. Kindly have the matter tomorrow.
Yes.
Take the value tenders.
Yes, verify and list tomorrow.
February of 2023, it's a state extension matter. Lots of directed listed today. The stay has already expired.
Yes.
Already informed them.
Yes, 2:30.
Actually, petition ordinance is completed. Further ordinance of this ordinance, it is posted on 6th, but it is not listed. Kindly post it tomorrow in newsletter.
Verify and list on 15th.
It's addressed by
Yes, verify and list on 15th, I said. Yes.
With my lord permission, my lord, may I mention, my lord?
Yes, 1 second. Yes.
regarding property tax.
Yes, verify and list on 14th. Yes, you have enclosed a copy of the letter. Yes, hand it over to the court officer. Yes, verify and list on 14th. Yes, verify and list on 15th. Yes, verify and list on 15th. Yes, 15th. Yes,
Still listed on 18/16/8 of 2023.
yes, verify and list on 16th. Yes, call the list.
With my lord permission, my lord, may I mention, my lord? It's a parted matter, land acquisition matter, my lord.
Yes,
Yes, my lord. Whatever you date, my lord, is a 2003 matter, my lord. Writ petition number 12015/2003 is a parted matter, my lord.
yes, verify and list on 16th.
Oblige, my lord.
Partards only on Thursday and a Friday hereafter.
Yes, my
call
lord.
the list. Yes,
Item 19 and 20, because it's already in the matter passed.
19 and 20. Item 19 and 20. The request of the council.
With your permission, my lords, I'm sorry to interrupt, my lords. It's item 30. I'm just renewing my request. If your lordships may be inclined to hear them tomorrow, I'll get the counter by today evening. I'll place it on record, my lords. And I will argue on Tuesday once they finish their submissions tomorrow.
Yes, the
Please,
council, the council is not here. We'll see when it is called at
very well. Very well. I'll wait for the matter to be called out, my lords.
the absence of the. Yes,
But 26 months. Now, find the Bakalat for the response.
can you wait till item number 26? Yes. Call the list now. Yes.
Item number 1, admission education. Joseph Sriharsha, Mary Indraja, Patil person, GP for higher education.
File is very big, the issue is very small. See the third round, but in the first round, I filed the plea petition for challenging the input letter of rejection to start a private university. It was rejected on 2 grounds. First ground, I did not obtain the report of the expert committee. Second, there is I did not challenge the report of the expert committee. She held that the input letter is based upon the report of the expert committee. This court cannot exercise judicial review on the 226.
Yes.
But the second round, I filed review. The review was dismissed on the ground that the scope of the review is very limited. But this court did not test the validity of the impugned letter for no challenge to the report of the expert committee.
Yes.
I was supplied the report of the expert committee along with the counter file in the review on 11/8/2023, and the instant writ petition is filed challenging the report of the expert committee and the consequential impugned letter of regret dated 26/10/2020. I just take few minutes to convince your lordship that this writ shall be allowed at the appeal stage itself.
No, it cannot be allowed because your proceedings is dated 18th March 2021. You take out notice to the response. Yes, Randy.
I just take 2 minutes to convince your lordship of the
Without,
interim trial.
without hearing the other proceedings is dated 18th March 2021.
Beyond Mr. Game on advocate and taking notice for R3 year.
Yes, Randy. Notice before. It's 5th December. Yes. 28th December. I say 12th December. Yes, 12th December. You make an effort, we'll consider on 12th. Yes, call the next.
Admission Universities, item number 2, G. Satish Babu.
Prior to 1819, all these students from the currently up to 5 children it's credit points to provided to the students. The academic level, all the students are who are created two subjects. The credits are allotted to the benefits again provided to engineering. Again, 2016, 2017, 2005,
Yes, have you addressed any representation?
They had made a
How can there be any mandamus without you even requesting them to look into the matter?
Himself admitted in the epidemic that there is no regulation at all for the university.
Yes,
Only that was considered
during the COVID period. Yes.
measures has not been taken.
the college has to make the regulation. All the institutions are affiliated institutions. All the institutions where these are produced their study.
You have not even represented to them. How can there be a mandamus? How can you say there has been inaction?
With regard to that paper cutting, we have made a demonstration. We have
I'll permit you to make a representation and let them consider within 2 weeks in accordance to law. Yes.
The academic year,
There is no regulation. There is no regulation. Yes.
The academic year is academic year was started. In 6 months, 3 semesters are completed. So it's supposed to be completed in 1.5 years. 3 semesters in 6 months of period. And time was duration of examination was reduced to 2 hours, 3 hours. Lot of hardships are faced by this university is supposed to make a regulation. It's very good.
item number 2. A confusion, typical higher education.
I'm not fast enough. Yes.
During the action of the response, driving the right of the petitioner, signing into the admission of the petitioner Joe is native of the Telangana. Though he studied his till intermediate education in Telangana, except for the graduation from Delhi. Your lordship may kindly take the notification, not under their own notification. Notification, rules and regulations, not elected lordship of the page number 32.
Yes.
Roman 7 below. The group of local, non-local states and candidates. According to the rules in force, see Annex 1, Annex separate, Annex 2 is active. Those who have studied for at least 4 consecutive academic years ending with the first appearance in the qualifying examination as regular students need to submit only the bona fide certificates from the colleges, schools where they have studied. In case the candidates have studied 4 consecutive years preceding the qualifying examination in more than one local area, the candidates must submit the bona fide certificates of at least 7 consecutive academic years ending with the first appearance in the qualifying examination as regular students. In case the candidates have not studied in any education institutions during part of 4 by 7 years preceding the qualifying examination, they have to submit a certificate to that effect from the concerned under revenue officer. Here we are, the petitioner here is studied from 1st class to 10th class in Suryapetti district, and intermediate studied in Hyderabad. But graduation, he went to the Delhi and he pursued the BCom, Bachelor of Commerce course in Delhi 3 years. Thereafter, he resided in Telangana for preparing the competitive examinations. Thereafter, the second respondent university issued the notification for common entrance test, postgraduate common entrance test, where he applied for online. He got issued the hall ticket. Thereafter, he appeared, he got secured 76th rank in the entrance test. He participated in the first phase counseling. Your lordship may kindly take page number 42. 41 is the rank where he secured 76th rank. The 42nd is the first phase participation of the first phase counseling, where he opted with options in 6 colleges. Only 1 college in 5 options, and other college in the 6th option, where he got seat in first phase counseling in the second college. Second exercise of options college, MCOM marketing. Where your lordship can take the page 44. Thereafter, they have verified the certificates through online process. Then thereafter, they advise you to pay the course fee. Is page number 44.
Yes.
After he paid the course fee also. Then he did not satisfy with the MCOM marketing. He exercised the second phase counseling by exercising the 1 college option because already got seat in the OU campus, and he opted page number 45. In second phase counseling, he exercised options MCOM finance, where first phase counseling he opted MCOM marketing, where he got selected paid fees, but he did not satisfy the marketing. Then he exercised the option in second web counseling at page number 45. This attest applies to the petitioner. Your lordship can take page 46 without being any intimation and any notice. Cited to the principles of national justice, where he verified his allotment status. This status not allotted. The seat was not allotted. It is not the purview of the petitioner. If they are not allotted the seat in the second phase counselor, the first phase counseling seat has to be confirmed. So he pays the court fees. Now, thereafter, he made a representation to the official website through mail. You lordship kindly take page 51, indicating that reason for not allotting the seat, they confirmed the acknowledgement to page number 52. They did not give any reply. Now they are saying that through phone call, where the employee numbers were provided, they are saying that you have the non-local to take Telangana. This reason he cancelled your allotment of the seat in the first phase counseling. There is no correspondence, there is no notice. It's violation of the principles of national justice. Your lordship may kindly take the Annex 1 of the frustration order. Invite your lordship attention, which is annexed to the notification. It's a page 36.
Yes.
Page 36. B. The local candidate. Look, may I read here?
Yes.
A candidate for admission to any course of study shall be regarded as a local candidate in relation to local area. If she has studied in an educational institution or educational institutions in such local area for a period of not less than 4 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying examination. Well, it is a clear case that he consecutive 4 years he did not appear from the state of Telangana. The second miller, during the whole part of the 4 consecutive academic years, ending with the academic year in which he appeared, as the case may be, first appeared for the relevant qualifying examination, he has not studied in any educational institution. If he has resided at the local area for a period of not less than 4 years, immediately residing that the date of the commencement of the relevant qualifying examination in which he appeared, as the case may be, first appeared. The second candidate for admission any course of study who is not regarded as a local candidate is subparagraph in relation to any local area shall, if he has studied in an educational institution in the state for a period of not less than 7 consecutive academic years, ending with the academic years in which he appeared, or as the case may be, first appeared, the relevant qualifying examination be regarded as a local candidate in relation to. My case fit in the local candidate 2-1 villa, where he studied up to intermediate in Telangana. Then he shifted to the Delhi for pursuation of the BCom course in Delhi. Thereafter, he shifted to again to Telangana and he prepared for the competitive examination. Out of 7 consecutive years, immediate to the qualifying examination, he stayed and he studied in Telangana. Only 3 years he studied in Delhi. They cannot reject the case on the ground that he is the non-local winner. But it's a submission. Your lordship is well aware as per the presidential order, even otherwise also treating the local candidates for the purpose of employment, the school education has to be taken into consideration.
Who appeals for the respondent? What do you say? Obtain instructions. Yes. So far as the issue with regard to local area, yes. This in motion list on 14, notice before admission. In motion list on 14. Yes. 15. List on 15.
I may exercise options in third place, but they cannot confirm. I being a local candidate, I secure the 76th ranks.
Let him obtain instructions. Consider. Yes.
Item number 4. Nirmal Kumar Pandey.
Yes.
Student of final year, he completed the year internship. The internship was not evaluated by the college. Even though he has completed the internship for 1 year, he has produced the internship certificates from different hospitals also. He has undergone 2 internships, one for 6 months in different hospitals. He has issued a legal notice to the college as well as the university also to evaluate his internship. Till date, the college, for the reasons based on they are not evaluating the internship of the petitioner.
Yes.
The notice to the college as well as university is at page number 20.
This who appears?
Board respondent has to send the records of the petitioner. The third respondent has to evaluate the internship. But in this case, the fourth respondent has not sent any record. If they send the record to the third respondent,
This who appears for the fourth respondent?
it is to go to the fourth respondent.
Yes, friend. Yes.
Item number 6, admission centers. Sorry. Item number 5, Cyprus and Bundavar.
The case the inspect that in the subsisting tender the law issued to the petitioner, another tender was issued to the no cancelling our bid. But the facts are the petitioner is not tender in first comes to tender notification dated 24/1/2021 and page 35.
Yes.
The duration of the contract page number 46, the duration of the contract is for 3 years. It's the security services contract granted to the petitioner.
Yes.
You also may find page number 46. The minimum period of contract will be 3 years from the date of construction starts. If the service of the service provider is found satisfactory during the period of contract, the contract can be renewed after expiring 3 year contract period on mutual consent by 1 month written notice. Thereafter, the tender was allotted at page number 50, 29/7/2022.
Yes.
The above the university has appointed your agency for providing security arrangements at the university campus, initially for a period of 2 years with effect 1/8/2020. The rates agreed by you as per the details shown below for an amount of 5,37,639 per month. The contract is subsisting as of now. Agreement was also entered into at page 54. Now, my lord, a tender has been issued. No strictures have been passed against the petitioner. No memo has been issued, and the tender allotted to the petitioner was never cancelled. Surprisingly, now another tender is issued at page number 20. Same tender to provide security services at the campus for the first response. Page number 20, Page number 20, the tender starts. Scope of work, your lordship,
Yes.
to maintain 24 hours food security at the university at various locations within the campus premises, the agency shall maintain security. The agency shall restrict the entry of unauthorized persons and not follow them. The agency shall check two by the vendor passes, delivery passes, which is the same tender issued in the petitioner. But you can compare it to open work at page 38 of the earlier tender. Challenging this subsequent tender, if I look at the petitioner has also submitted the representation of 30/10/2023
Page
71. Now the issues bids are due to open today, and the tender may be allotted to third parties on November 14th. Therefore, we are seeking a short stay of this tender.
who appeals with the respondent. Yes. What do you say?
Okay.
20th?
14. What should we see? 23 page from 23. Parts of price bill November 14 to 2023 at page 30.
Yes, we posted in motion list on 14th. Yes.
Third party certificate is created.
I'm posting it on 14th itself. Notice before admission. Then it counts as a respondent to obtain instructions in motion list on 14th. Yes. We'll consider, let him get instructed.
Technical.
Let them obtain. Let them obtain instructions. Yes.
Central government item number 6. TPS Harsha, Gadi Praveen Kumar, Deputy Solicitor General of India.
Sir, where this award was made by the B and that was stayed by the Rakesh Agarwal. But while that writ is pending, without mentioning that it will issue the details, after the police is issued, contrary to the RBI guidelines, the second action, when first action is already pending, but absolutely unheard of, and that is what is under the accused proceedings. So these are the list of dates. Very quickly, just 4-5 dates. And that's whether it is a forward conclusion and pre-judged question, which is exactly what the Honorable Supreme Court said cannot be there. You have to read the person, swear and give some purpose.
Yes.
Yes, but the first one, the first thing was don't be taken. Then, on 2021, fraud declaration by bank, which we were not aware of. This was paid by your. And then the subsequent criminal complaint, then an FIR lodged, then expedition filed for 2123 of 2023. Interim order passed on 16/8/2023. In that order, declaring that fraud as illegal. An interim order was passed, it is still pending. But it is on the same lines as the Honorable Supreme Court judgment. Unlikely to balance. I'm just arguing that once that is pending, this impute show cause notice of 26/10/2023 in respect to the same facility is issued without referring to the writ petition, without referring to the earlier action, without referring to the RBI. But it's a clear attempt at overreaching this honorable court and to defeat the proceedings before this one. I mentioned the grounds for it under constitutional challenge. On every ground for this is liable to be settled, each of which is a sufficient. We are overreaching. But
Let us see the earlier order of this court.
Yes. The earlier order of the case should be enforced. After that, after 3-4 lines, where the user of the content of the then apex code launches. See that the judgment of 2023 State Bank of India versus Rajesh Agarwal and others. And 94 and 95, it does fall. But this is the recording. That before concluding, we also must attend the action for the borrower, so the requirement of the agent order must be ready to master direction for the borrower. Also, the kind of charge. The final decision of the review committee.
Yes, I have read that 94 and.
After these two are extracted, the payment uses the relevant paragraph to the indicate that it is mandatory for the bank to provide a reasonable hearing to the borrower and also the body of the account has to be necessarily followed by the account as far as is admittedly not being done in the present position. And the same is clear by the taking into consideration the above mentioned factors the law and others. The action taken by the respondents and classifying petitioners account as a suspended for a period of 6 weeks. This is being extended to 9 weeks. While this is happening, the law not is impugned. So that fraud declaration is there and it is suspended for improper action and contrary to Supreme Court. But this one, overreaching the order, does not refer to any that order on page 19.
Yes.
Throughout I have read, they don't even mention this petition. They don't even mention that this is already stayed. They don't mention that fraud declaration of they are setting aside or withdrawing it, and they just issue a second notice as if it is a foregone conclusion. Once again, violating the state of the Supreme Court because they refer to some forensic report which is not mentioned. Also, overreaching the article, this article of the court, and that adjudication is already made.
Yes.
Can I respond in the there is
Respondent number 1. Appears for the HDFC Bank. You appear for respondent number 1. Yes, friend. Yes.
Item number 7, GL Narasimharao, Gadi Praveen Kumar, Deputy Solicitor General of India, Chief for Revenue. Pension from they have passed
They have stated in your lordship, I am raising the 17th. Yes, your lordship. A and B to the both the petitioners were granted from 28 to 2023. Rather than considering the application date, they have considered the this part. They have not even considered two applications your lordship, and they have stated even up to the
Yes, friend. Yes, in motion list on 21st.
My name is Srinivas.
Yes.
Item number 8, Mallu Nathan Reddy, Sadi Praveen Kumar, Deputy Solicitor General of India.
In respect of a person who is in respect of convertible preference shares which were to be converted on 25th October 2023. Redeemable preference shares of 2 lakh rupees invested on the basis of an agreement where the group would exit this company, which the original business starts from 1980 and 1999, and then we had that culminated into a particular company from Singapore who buys the shares of this KFintech. This group became a minority shareholder, the HUL, in the KFintech for General Atlantic Group 1. But in order for me to exit the entire company, they said 2 lakh redeemable preferential shares are being given to you, which will be redeemable after 2 years, that is on 25/10/2023. On that date of redemption, but I was to be paid 134 crores. But in the over enthusiasm, the ED goes and attaches, issues a provisional attachment order even before that money is converted to me and paid to me, who is not an accused, whose father may be an accused in the cases. And this money now is kept by the third party company, the Singapore company, saying that ED has attached to your 2 lakh rupees worth RPS, therefore I will not pay 134. But I do not understand the logic of ED, where the money itself is not there. 23rd October, they pass an order. 25th October, it is supposed to be converted. They are attaching a property that does not exist. Not just received the date of the impugned order. And from the impugned order itself, I will show they themselves say it is to be converted, it is to come in 25th. And they pass an order on 23rd. Unborn asset is attached. Now that company is taking advantage of this. Between both of us don't get this money, neither ED nor me. That company is taking advantage and saying ED has passed order and not 134. They are keeping the money. I will show them the things for 1 minute. And then I will come back to the ED's own impugned order, where they record this date. Absurd order totally. Page 6, P6, you also page 161. And no notice is issued to me. I could have explained this transaction is going for 1 year. They know about this transaction for almost a year. The company KFintech has written to them to 1 year back. And I'll show that Lodges may note page 161.
Yes.
But fifth reference in that letter is order dated 23rd October 2020. Now Lodges may see second paragraph. Pursuant to the agreement, the company allotted RPS, that is redeemable preference shares. On October 25, 2021, the RPS, in accordance with their terms, were redeemable on the second anniversary of the allotment of RPS, that is on 25th October 2023, subject to the compliance with the payment conditions set out in the Schedule 1 of the agreement. Further, the company has a right
This is a very fair. What was the parameter? They said it will pay 134 crores to me on 25th October. The subsequent to the completion of the meeting of the members of the company approving the buyback, the company received a copy of the order of ED on 23rd October 2023 at 6:24. The ED has provisionally attached the redeemable preference shares and further directed RPS cannot be transferred, disposed of, and parted with and dealt with in any manner. Consequently, the payment conditions set out in paragraph 2 of the schedule 1 of the agreement, which requires that no proceeding or claim of any nature should have been initiated inter alia against any shareholder of the company in relation inter alia the transactions contemplated on the agreement and the payment redemption premium thereon and the redemption by any person is no longer satisfied. Further, since RPS have been provisionally attached, there is an embargo imposed by ED on dealing with RPS in any manner. We understand that the RPS held by you cannot be tendered for buyback on account of the ED order, despite the company having undertaken all steps, obtained all necessary approvals, completing the buyback at its end. In view of the above, as a result, the payment conditions not being satisfied with provisional attachment of RPS pursuant to the ED order, company is not in a position to proceed with the buyback at the present, although it was and continues to be ready and willing to perform its obligations under the agreement. Further, given that the company is unable to proceed with the buyback redemption of the RPS on account of the payment conditions not being satisfied, there would be no dividend or interest that would be payable by the company with respect to RPS or redeemable preferential shares. Now, let's see the income order. So, with this money, the third party company is keeping, we are not getting it, and no interest will also be paid. So, they are saying, I think what they have to do. It is a income order at page 19. Important date, just may see the date of this order. 23rd October 2023. Watchers have that.
Yes.
Now we watchers may see their own description of this particular shares. Well, that is at page number 74. 72 below the description starts, but 74 is a relevant portion. Two paragraphs which clears the case. They're attaching something that has not become my property, and they keep it as two lines. Mr. So and so on 25/10/2021. As per the condition laid down in the said agreement, these shares are eligible for redemption after a period of 2 years. That is on 25/10/2023. 2 days prior, they issue this notice, noticing very well that it will become redeemable 2 days later. The value of the redemption is so and so 164 crores, but that has been reduced to 134 crores, which is at paragraph 9.4.11 and 12 below in the same page. Just permit me to read 9.4.11 and 12 below. Further, total amount invested for acquiring these redeemable preferential shares is rupees 2 lakhs, which shall also be paid by K Fintech along with the redemption premium termination fees. So, today, as of today, when I paid, I paid 2 lakhs rupees because I had fixed the earlier arrangement from 1980s that I was there. So, only 2 lakhs I paid. After 2 years, I was 134 next time. As mentioned, the total payable amount for redemption is rupees 134 crores. So, as per the declaration given by that is the petitioner, as per the declaration given by K Fintech, the third party company, to the stock exchanges, as per regulatory guidelines, which is payable redeemable 25/10/2023. Now, having noticed this, watchers will now see the schedule of properties they attach to the bottom of this entire. In page 84, what is the order? What is it that they attach? And what is the value that they ascribe to it? Page 84. Table. Schedule of properties. Mr. So and so, PAN number so and so, description 1000 non-convertible redeemable preferential shares having face value of INR 200 each. Value 134 crores. 134 crores comes once it is on 25th. All I'm saying, is this order may be suspended so that money comes into my account. I will not transact. I will give that undertaking. I will show as to how these monies are of 1990s and 2000, much before even the act came into force, much less an allegation made against my father. All these properties and now Lakshus are aware that section 2(1). There are 3 types of properties which are proceeds of crime. All that I should subsequent. Unless this is suspended, some third party will give the money, which is K Fintech. Third party company. Let the money come into my account.
by suspending this, so that KFin cannot use this order for non-payment. I will have 134 crores. I will give an undertaking before this order was put in this present petition, but I will not deal with it till the next proceedings. In this case, but that is what the ED wants. Attachment. Attachment basically should not be dealt with. I will not deal with it. It will be in my account. It will be in a fixed deposit kept, so that there is an interest that will be borne till this decision is made that these are cannot be proceeds of which can be attached, which is a very simple case to show. I'm not going into that today only for the reason that it is illogical for them to attach something which is not there. Let that become the problem. Now, the RPS is a paper which is first which I paid in 2 years, which is pursuant to my exit arrangements with the Singapore company long time. Today, I don't have this 134 crores. What is it that the ED is attached? I ask myself. And who is benefiting from this? Neither the so-called all allegations against the fathership in respect of some bank loans, etc., unpaid. That is also because of SEBI regulations being changed. I will get into all of that subsequently.
Yes, what do you say?
There is a money against instructions for
Yes, right. Just 14th in motion list. Yes, Monday is a holiday.
Ladies, item number 9 for the withdrawing. Malu Nathan Reddy, Rai Praveen Kumar.
It's all with liberty to file.
Yes. See the conference. Nurse this way.
Number 10 for dismissal. P. Bhaktavatsal, KGK Prasad, R. Naresh Kumar Reddy. Item 11. NV Subaraju, IV Ramesh, DV Srivastava.
Is cause of action survives? Ready.
There are so many.
Yes.
Item 12. K. Venumadhav, GP for Education.
Yes.
LTF 23.
IE?
LTF 23. Was already ordered. This is served, I filed.
The period regarding things that has been completed. I think my document has been made we have the association. Now the association has is basically no more now he has tried a separate petition to include the series. And then there are more of the with regard to the previous with regard to running of the school without permission, that is with regard to service all I submitted papers saying that school is running in the blue.
Seeking? There is no IE number. Yes. What do you say insofar as IE number 1 is concerned? Yes.
At the same time, your Lashma kindly consider earlier while this petitioner, the writ petitioner was treasurer and he was authorized to file a writ petition, therefore this writ petition was filed. Now my referent is coming on record on behalf of association. Then I filed a petition to grant leave. I am also having a personal grievance against the respondents number of running a school. Therefore, I filed a petition to IA at 1 of 23. So it's IF 2 of 23. Grant leave permitting this petitioner in individual capacity to prosecute this petition.
You wanted to file counter to this? Yes, right. Yes. Yes.
Item 13, Ponnam Mahesh Babu, GP for Medical Health Family Welfare. Yes, sir.
Only requesting for Tuesday. Council. So filing counter list on 14.
Item 14, Indus Lover, Sharath Sandeep.
If it takes considerable time, then soon after passos and lunch motions today. Soon after passos and lunch. Tomorrow,
Next week, virtually.
tomorrow, next week. Yes, right. So, I said 15th, list on 16th.
Item 15, M. Vijay Kumar Gaur, GP for School Education, Additional Advocate General.
District level, presently, local level, they are purchasing the agencies, meeting agencies. They want to state, but posted for.
Any counter file? Who appears? Yes. 1 week time. Right?
You have December 84, 94 is, but they have to implement that.
Also, present. List on 21st, orders extended till 24th. Yes.
Item 16, 16 and 17. Narasimha Reddy, GP for the.
I am representing only 16 men. In this case, my 13th of this month, this court has implemented sumo UGC for filing the counter. Until now, it has not filed the counter.
Yes.
It has to file the counter to make my stance clear.
Yes, who appears for UGC? Who appears for UGC? Yes, name of the council is printed. Yes, name is also printed. Yes.
Counter of UGC is necessary, my lord, as directed by the court.
Password, we'll password and see.
There was a direction to decide the issue on Article 15/11/23. Whether it was issued by of it was equivalent to degree. There was a direction to decide on or till level 23. With regard to 17 matter lordship, they have challenged the 23 TSC notification lordship, wherein last date for submission of application has been over. Even first court has been declined and further time. This is the application note. This is the order. Last application by the first court has been granted. This is the application note. It was declined. With regard to 23.
Have you given a copy to them?
Already learned this subject. Teachers, government, other issues like
Have you gone through this order? Have you gone through this order?
I'm considering only 16, madam. I can. 17, my friend has 5, madam. 17, I get considered purchasing of qualification of the over at 28 you got. You have the same thing. First one, refuse to is there. And
We are bound by this order, isn't it? Item number 17, division bench order.
Because in fact,
Yes.
this matter which is before by NCP, that is filed after the date is expired. I have filed the restriction of date 2023, whereas the last date was 2023. From my repetition, I only to equivalent to B. The requirement was after the cancellation of the GAO in the year 2017. So, government was given the time till 1511. But my difficulty was these petitioners, they have qualified LPC. A notification which was issued subsequently for the secondary grade teachers of Hindi was about to expire by 2017. Therefore, I filed an application on 10/10/2023, seeking a limited prayer, interim prayer to allow me to apply subject to the result of the decision taken by the government by 15/11/20.
What was the last date?
Even earlier,
28?
28, 10 you know. Earlier, in earlier, the last come up for you have cannot wherein in Kisan Able Court and 9th Court also, this is to grant
The point
relief with regard to the point preparation like the target has been over in last. Here, request for filing of counter. In earlier, no, not to
the bank grievances like this. That's why I market it. Please let me know the
We'll go with the division bench order, right?
May submit one.
Yes.
Because these division bench order which has not been considered, there the application is filed after the date is over.
But fact,
In the prior to that, division bench is allowed the application which was filed during the scheduled time directly to consider their application and also say it will be subject to result of the application.
is that we'll the same.
I request, Lord, I can verify whether it is filed, let it be passed or
I am not disposed. I am not disposed of that. Yes. Yes.
Item 18, Pramod Singh, GP for School Education, Kalvala Venkata Varakasa.
Direction to be considered.
I made my appearance on behalf of respondent number 4.
Yes.
This stuff, and I have to receive the material document enabling me to find the document.
Yes. Right.
Right.
Item number 21, Nageshwara Pujari, GP for Higher Education.
Yes. Right. On behalf of petitioner indicated that counsel for the first respondent is present. Just on 24th.
Second, 2, Admission Central Government, Ravi Kondaviti, B. Nalit Kumar.
Yes.
The petition strikes are non-payment of interest on savings bonds, government savings.
Yes.
It's better than grant, better than deposited crore.
Yes.
Subsequently, they expired in 2008. Before expiry, she passed away. So she expected to be in favor of the petition. But when the petitioner applied for maturity before the date, few days before the date, they declined the claim saying the will has to be completed. But the respondent petitioner responded to the letter saying there is no requirement for probate. Did not accept it. So petitioner filed a writ petition.
Who appears for the respondent? Reserve Bank.
Reserve Bank.
Who is the counsel?
Says Nalin Kumar.
Is the name printed?
Yes, sir.
Yes.
So if there is a petition because it's on the court challenging their action, we're making payment. So there was a direction for the respondent to release the amounts without payment. RBI went appeal challenging the petition. Writ appeal was dismissed, directing the bank to pay amounts. Despite that, they have released the amounts, but even though the amount was kept with them beyond the maturity period, 4 years to be specific, they have not paid for the interest on the amount period after maturity. It's clearly their motivation. They repaid the amount to them on untenable grounds. which were held to be available by this order, patient nature of this order. Yet they did not make payment of the interest of the order for 4 years.
Yes. Where is Mr. Nalin Kumar? Password?
Under the British order.
That's why I said he's not here.
Yes.
Just to hear him, is it not?
Yes, sir.
Yes. Password.
Item 23. Prasad Rao, Vevulapalli, T. Suhasini.
And issue two.
GST reimbursement of GST. My submission is, I have submitted some documents with regard to agreement which was entered by the contractor and the road block. As per that agreement, we are not entitled for any reimbursement. Since we are filed a petition for reimbursement of amount. Since GST was introduced, and as per we have reimbursed 3% of amount, 15% which they are claiming. As per the agreement, we are not entitled. So, Lakshmi kindly give me 2 weeks starting time by way. I have filed my counter affidavit. Agreement documents which they is in our favor that I was not filed. Need 2 weeks time as a last chance. Since they will priorities, Indian priorities to fix their so yes.
They're relying upon certain documents they have and they have not filed, but at the time of vote, they should have filed. Now, we cannot take an objection to that. My notice of granting time maybe a week, not be on that because I am not reviewing from 16th to 25th.
After this, 28.
Very well. 28 is 26.
Council for the I said 26.
And then 25th is not.
Yes. 28.
Very well.
Yes, 28.
Finally.
Finally.
Item 25. Kailash Nath PSS. Guard Praveen Kumar, Deputy Solicitor General of India, Asnal Ravi Babu.
I just made my submission. The same IA has been returned your lordship. Compare with the subsection. Request for just 1 more day of time, your lordship. We compare with that. I have the return copy as well, your lordship. It has been returned yesterday, your lordship. Just 1 day of time.
I said tomorrow.
Tomorrow, your lordship. Tomorrow.
She's only requesting tomorrow. Yes. Tomorrow, finally. Tomorrow, finally.
Whether it is listed or not. Nothing to do with this amendment. I have filed a vacate petition to vacate the court interim order. That amendment is not for an affidavit.
Yes.
Right. Nothing, everything they have taken in the grounds and
No adjournment tomorrow. Yes.
whether that is listed or not.
Ganesh. Raghavendra. A. Raghavacharyu, P. Anil Mukherjee.
Yes, right. Petitioner is present. Counsel for granted. Yes. Item
28. Bhargava, Magadi, MP Rajkumar, Gatley.
I find my cost on the documents that the transaction paid by the petitioner has to be filed for adjudication of the petition.
petitioner is present. This is the counsel take this point.
Will be costed for signature.
On the 16th. Yes.
Item number 29. Sudarshan Kambam, GP for Industries Farmers, Divya Adipu.
Application extension of the time for payment of the page number 16 as well as petitioner was supplying of manpower to the security guard. The second respondent had issued a notice under section 45 ESI Act, paying of 59 lakhs 77,922. As reported as statutory appeal are requesting to grant some time that is the first respondent is directed to pay 20% of amount that could not be paid in the time of the enlargement petition that was dismissed. I am ready to pay the amount which has been given granted by the first respondent 20%, 11 lakhs 9,000. Page 16 is the docket notification. The page 18 is order passed by the first respondent, granting time and the statutory appeal for remembering the appeal application has to pay the 50% of what was demanded by the first second respondent. For that, I filed an application. Page 20, page 18. Order passed by initially order passed in 12th May 2023. Granting giving a time to pay on or before 12/6/2023. Subsequently, I filed an enlargement petition. Page 16. 18th August 2023. I'm taking before the sum. I'm ready to pay the amount and granting some breathing time and
There is your lordship. I appear on behalf of the respondent TSIC Corporation, your lordship. My humble submission, your lordship. The TSI Act, your lordship, is a welfare legislation and it's a comprehensive legislation with respect to every remedy, your lordship. There has been, in fact, your lordship, this repetition itself is not maintainable, your lordship. He has a statutory right of appeal under the TSIC Act, your lordship. The petitioner herein is a defaulter who has not paid the contribution, Your Lordship. He's preferred an appeal before the court, Your Lordship, which mandates a 50% deposit of the fee. Even that amount has been waived, Your Lordship. He is defaulted to an amount of 60 lakhs, over 60 lakhs, Your Lordship. Pursuant to which, Your Lordship, he has filed an INA for waiving or reducing. Accordingly, the EI court is considered his application and waive the amount and only asked to pay an amount of 95,000, Your Lordship. In spite of the reduction of the fee, Your Lordship, given to the EI court, Your Lordship, the petitioner has been dodging the issue and only has been delaying, Your Lordship. In fact, Your Lordship, the docket order, after 18 May 2023, Your Lordship, he has directly approached this honorable court, Your Lordship, without paying the mandatory fee for the allowing the appeal, Your Lordship. This honorable court has granted an interim order, Your Lordship, and pursuant to which vacate and counter has been filed, Your Lordship. In case that in fact, Your Lordship, these contributions date for very long period, Your Lordship. In case the petitioner after the order also, Your Lordship, it's almost 3 months. The petitioner has protection. Even at this instance, the petitioner is again reiterating his request for time, which shows nothing but his effort to delay the entire process, Your Lordship. And TSHC Act is a welfare legislation, Your Lordship, for the benefit of the employees, Your Lordship. And having not paid the contribution, Your Lordship, and in the case, Your Lordship, that there is a statutory appeal, Your Lordship, the present writ petition itself is not made available. Having gone with the EI code for reduction, and after the amount of reduction happening as per the prayer of the petitioner, Your Lordship, cannot come before the honorable court seeking the extension of time for the same, Your Lordship. The petitioner does not seem to have any intention of paying the statutory mandated fees under the TSHC, in spite of reduction of fees, which is 20%, Your Lordship.
In the prayer or enlargement petition, it was dismissed. It is dismissed as preferred statutory appeal for the first respondent. The condition is leaving of the 20% to pay.
It has already been done, Your Lordship.
Yes.
I'm ready to pay when I'm from breathing. The body the sister says, no, but I'm ready to pay. That's from breathing time I get. I'm 65 years old. I have no business from the day.
You put it on record. You put it on record by way of an affidavit. By what time you can pay? Yes. Put it on record by way of small affidavit. Yes, friend. Yes.
If you pledge.
Item number 30.
With your permission, my lords.
31. Pavan Krishna Reddy, Gadi Praveen Kumar, Deputy Solicitor General of India, TVL Narasimha. 30. Morning
30th, you lost it.
30th. Mali Vintana. Is now subsequent to your mention. Subsequent to your mention, again, the mention was made saying that the matter may be tomorrow and the counter would be heard today. That was the representation, but I said no counsel is present.
Taken up tomorrow, now. She is filing a today.
I said, no, not today, my lords. I'm sorry to interrupt. I'll be receiving the counter by today evening, my lords. I'll file it tomorrow in the morning hour. If your lordship pleases, the matter can be put under the 2:30 caption tomorrow afternoon, my lords.
2:30 tomorrow.
Yes, soon after passos and lunch.
Yes.
Yes.
Very well. That can be done. Obliged, my lords.
A representation was made in the absence of the counsel. So I said, you make the same representation.
Disturbing the students have no hurry. I can wait till Tuesday also. First occasion, your lordship very clear that this matter is sub judice. If they have not taken any harsh action, it can be taken up on Tuesday. I can wait. But the counter in IA will not be completed anything new.
Yes, the matter can be heard tomorrow, my lords. It will be completed tomorrow itself. Your lordships can pass appropriate orders. It doesn't have to wait till Tuesday also. I'll file it in the morning hour and we can commence submissions tomorrow post lunch, my lord, so that the counter is on record.
What do you say?
We can have it in lunch portion.
That's what we'll do.
Soon after passos and lunch. Yes.
Very well. Obliged, my lords.
Again, this thing is a common way of making it. That's the registry is not.
Is it so? Not in this court. Not in this court. Yes.
32.
Yes.
I get to petition your lordship. Last occasion, please to hear me
Rasta. Yes.
Lordship was pleased to hear me at length. The case is pertaining to freezing of bank account under section 91A of CRPC.
Yes.
Your lordship on the last occasion was pleased to record it in the docket of the judgment which has been passed on Madras High Court. I have an extra copy.
Yes.
And also the petitioner did not serve the medical statement. I have no objection to that. With respect to that, lordship may take page number 23 minutes. They have been served with a notice that crime branch of Delhi minutes saying that my account has to be frozen because I have received illegal proceeds from an accused minutes. Lordship may read it. It says notice under section 91 CRPC and FIR number 17 of 23. With reference to the above notice from the police station after Northern District Delhi, and provided the details, your account has been marked as debit free. They could not have done it because under section 91 CRPC, they cannot freeze an account. They could have asked for the details, I could have produced it. Merely on the basis that the facts are others. I'm a cryptocurrency user. I have downloaded an application called Binance. In the said application, I had certain bitcoins and I've sold the bitcoins to a third party. The third party had approached me through the application itself. And apparently, under section under FIR 17 of 23, the said person is an accused on an application on a complaint made by a third party saying that he's been defrauded. I have no connection to it merely because I have received the proceeds. They are stating that my account has been frozen. Your lordship will take a Madras High Court judgment which has been passed along.
Yes.
Para 9 of the said judgment. It is clear that the first respondent has no jurisdiction. In the summons issued under section 91 of CRPC, the investigation officer summons the persons to produce the document or other things. On the summons issued under section 91 of CRPC, account cannot be freezed. That apart, the first respondent failed to comply with the procedure contemplated under 102(3) of CRPC. Admittedly, the first respondent failed to inform the freezing of the petitioner's account to the concerned jurisdictional magistrate, even till now. However, the petitioner himself admitted that he placed order for purchase of the cryptocurrency from a user named Raj Ghosh on 21/2020. Here, what has happened is similar situation. amounts had been transacted. The said amount which is under dispute or which has been stated that it has been illegally received has been put in a separate bank account and gives permitted to use the said bank account. I have no objection because if the amount of 2,87,000 which is received by me after sale of the Bitcoin is put in a separate bank account, I may be permitted to use the bank. Without giving notice, without giving any information, my account. Despite asking for a copy of the section 91A CRPC notice,
Yes.
they did not produce the same. I've written an email to the police authorities also requesting them to give a copy. More details have been given.
Yes, when can the counsel for the bank appear? Yes, what do you say? Yes, I can post it only next week. Make an arrangement. Yes.
Limited prayer response. Meanwhile, it may be suspended or else.
We'll see, I'll post it next week only. Yes, without hearing the counsel. Yes. It's 17th in motion.
Item 22, in size and a half. Badi Praveen Kumar, Deputy Solicitor General of India, DP for whom?
Ready for hearing. If I submit my school petitioner here, it's 2 years. She is last academic year because of not issuing of Indian citizenship registration certificate. And
Proceedings dated 13 January 2023. Let the counter come. Yes, when can you find the count? Yes, when? The counsel for the petitioner is present at the request of the counsel for the respondent. For the purpose of filing count with the list on 21st.
Motion list.
Yes.
Yes. There is order for number 2 and 3. All the amendments and documents are in favor of granting citizenship to the petitioner.
This will dispose it all. Without a counter, how can it be disposed? Proceedings dated 13 January 2023.
Yes.
Yes, we are in November now. Yes, call the next case.
Item 23,
Yes.
RS Associates, Gadi Praveen Kumar, Deputy Solicitor General of India, CH here.
Please pass the issue order when it's in October 2023.
Yes.
Very well. By one of the respondents, we dispute of within a period of 2 weeks. My understanding is that it has not been disposed of so much.
Yes.
But in so far as the allegations in the writ petition is concerned, the respondent, the official respondent, that is respondent number 1, has clearly stated this in paragraph 16. The project kindly takes the counter affidavit which has been filed by respondent number 1. The controversy around is this: certain shares of the petitioner and similarly placed persons had been inadvertently attached by the first respondent in an action against a third unconnected party. So this is the allegation on which I had come to this order. If you should now please para 16 of the counter affidavit which has been filed in the first respondent.
Yes.
What he says is, on examining,
yes,
On examining the contentions of the petitioner and the documents submitted by KCL, it appears that the shares held in DVAC account IN number so and so are not owned by KCL. KCL product is Carmi Companies. And it is holding these shares on behalf of the erstwhile equity shareholders of Farm Enterprise Limited, including the petitioner in WD number 28373 of 2023. It is submitted that the above attachment was made on 28/7/22 when these facts were not in the knowledge of the department. In view of these facts and circumstances, the department is willing to release the said shares by the petitioner in WD so and so lying in the demat account. However, as pointed out earlier, the Division Bench of the report in its modified 5/10/23 has directed to maintain status quo with respect to the attached properties till the next date of hearing, that is 7/11/2023. There are 2 or 3 things Your Lordship may kindly consider here. If the respondent had disposed of the representation as directed by Your Lordship, it would have been for the benefit of the entire class of shareholders. They can't expect for small shareholders holding 10 shares and 12 shares. Cluttering Your Lordship's docket by filing 2,700 writs, because there are 2,700 people who are involved in this, has been admitted by the first respondent in its counter. Your Lordship, if we see a page number, there's no page number in paragraph 10.
Yes.
The total number of shares is about 46,422. This has been held by about 2,700 shares. If the ED expects each and every shareholder to come to Your Lordship and ask for release of these 10 shares or 12 shares, that would be an extremely unfair conduct on the part of the first respondent. If it admits that these shares do not belong to Carmi, the continuation of this fraud is absolutely incorrect. If they pass an order on the representation which is being made by the other respondent as directed by the Lordship, we can take steps for getting suitable direction from the Honorable Division Bench. They don't dispose of the representation.
Yes.
Because these shares have been attached to not inadvertently, and these shares do not belong, these shares are not tainted, these shares have got nothing to do with Carmi.
Yes, what is the difficulty in complying with the order?
If they comply with the order, I can take further steps.
Comply with the order. What is the difficulty? Advise them.
We have taken the my other friend will kindly appreciate what I'm trying to say. Let them dispose of saying whether these shares belong to Carmi or not. If they say these shares do not belong to Carmi, as they have candidly said in this counter, and if the representation made by the other respondent is disposed of, I'm not saying that straight away release it. Let them at least say that what prevents me from releasing is the order of status quo. We can approach the Honorable Division Bench and get that order. What is the difficulty in first respondent disposing of the representation and complying with Your Lordship's directions?
You say that you advise them. Yes.
I just read the 31 of my counter. Very clearly, whatever the three counts. Because very clearly mentioned that.
Yes.
But I'll just read out.
Yes.
Consider the other parts, but appear to the shareholder, the shares held in the demand account owned by the respondent before. Very clear, categorically mentioned. The counter itself. And it is holding the same shares on behalf of US by the statements of company. Why these facts were not within the knowledge. Now, when we have the facts, the departments try to release the shares to have the pictures from the order of the status to the property should be removed in the
pass an order.
No, let the order passed in July. Update was made in August, that is confirmation. Now, the presentation is in September. The data facts on record. There was no uncertainty in this. But now we have knowledge that is not clear.
Now the order now it was extended up to 29th of this month. But is there anything wrong in the Garland authority saying that we have done something wrong? That's good. That's good. And if it is anything happening, why can't they dispose of the representation? I'll take appropriate steps to get clarification. This good that is what it is. The order passed by
Waiting for response number 3. The representation which your lordship had directed to dispose of, I filed it along with my counter. The petitioners hold shares in response to the company. The representation that we filed along with my counter.
Yes.
If that representation is disposed of, all your
Already there is an order.
It's not a fresh event. When this time your lordship said without fail. The orders.
Nishan Adnan, Mahmood, Jhansi Bai, T. Bhaskar.
Yes. Yes, right. Yes, the counsel for the petitioner is present at the request of the counsel for the second respondent. It's after 1 week. It is on 20th.
Very covered your lordship has listed so the interim order passed on 12. So we have to get instruction whether it is covered or not. Very
Yes.
covered by
Yes.
issue of the
Yes, list on 20th. Obtain instructions.
I request motion.
Yes, in motion list. Yes.
Item 35. Gaurav and Rashekha Reddy. Gadi Praveen Kumar, Deputy Solicitor General of India.
Creating equity, putting the amount, insurance death benefits related to our SBI account. Treatment is same, petition the criminal. So the case of loss. The disease husband, the petitioner used to work with the TSHC, Northern Power Corporation, distribution company, used to work there. And he has availed a personal loan with the SBI Secunderabad. Was working with the corporation at Nigeria, went in a loan with the SBI Bank. And unfortunately, the husband of the petitioner diseased during the service of this loan, pendency of this loan. So after that, this loan was declared as an EPA, and later on, the bank preferred to file a money suit, paying the petitioner and her 2 children as the respondents, including her employee, the garnishee in the money suit. So money suit is pending. Meanwhile, the insurance death benefits were credited to her bank account. The free bank account. The same happened with them. The petitioner here is not a party to the loan. Whether she is a co-applicant and a guarantor, is no concern. And even according to the 15th laws, even if the money suit is decreed, this death benefits to insurance policy cannot be attached. So that is going on. They are taking their own legal remedy. Manisut is there, and they are defending. They have made their appearance as defendants, and they are defending. So meanwhile, pending Manisut, they have withheld these things. And my lordship, the petitioner is not employed. It's fully dependent upon his death benefits, all those things. They are minor children. Already the breadwinner has been deceased, and this way the bank is annexing.
Friend. Notice before admission, take out personal notice to the respondents.
Item 27, Kiran Palaputti, Gadi Praveen Kumar, Deputy Solicitor General of India.
Yes.
In division order, you brought the cases are pending in that submit before where the case is pending. Case after police verification, this passport was issued. No, he's involved in 6 criminal cases.
The usual order?
Usual order is not because the passport is already in the custody of the petitioner. Either he has to surrender before where the cases are pending, or he will be.
Yes. The usual order we passed in renewal.
Fresh passport. But here it is already here. Passport is petitioner custody of the petitioner. Not to directly to surrender where the cases are pending. Whenever you travel to property publish and take.
But there are more than 6 cases if I'm right.
Surrender the passport. Whenever he wished to travel, he surrender the passport as per his DSR. He passed the CSR. There is a detailed procedure when there is a criminal case pending for any criminal.
States that the country has to obtain the travel permission where the case is pending. That is actually
No, he is not traveling here. Whenever he wants to travel, he surrender the passport. Because the passport to take permission for the consent. After the police verification, the passport has been issued to the victim. He gave all the replies to the victim. Police has to be set aside. But there is no such a part in this posting any passport. There is no such part that he has to surrender the passport to the victim.
Yes.
page 2. Whenever an applicant is seeking case advisor, he complete all the steps, mention all the pending criminal cases.
That is when he wants to travel abroad, he has to take an objection certificate from the concerned criminal court, and we are ready to do that. But as of now, he is not wish to travel any. The single passport is.
you answer, submit your clarification to this letter dated 18th April.
Page 16, my lord. Page 16.
13th.
It is the group, yes, ma'am. 18th, very night. Petitioner has clearly stated that regarding the criminal cases and he is not traveling abroad.
Page number?
Page number 13 is 1, my lordship.
Yes.
And page 16 also he gave the detailed reply to the show cause notice.
But you are not referred to this 18th April 2023. Where have you referred?
Page 13 is not reference letter 18 April 18. Page 13, ma'am.
Page 13 and page 16.
Yes, ma'am.
Yes. Yes. Consider this and take a decision. Yes, right? Petitioner's application. Suspension. The letter dated 6th October 2020. 6th October 2023. Hyderabad oblique 30 POL oblique PLC oblique 315. Dated 6th October 2023. The Regional Passport Officer, Hyderabad. Submit commercial appeal on behalf of petitioner. Submits that in an earlier application, in response to show cause notice dated 18th April 2023, the petitioner has submitted a detailed explanation by the letter dated 2nd May 2023 addressed to the Regional Passport Officer, Hyderabad. And further, in response to the show cause
Please,
My
Lata.
lord, so for the petitioner in this matter, my lord, I request a week's time in this matter, my lord, as the counter is served on me yesterday only, in the afternoon. And it requires reply. Next week, my lord.
The counsel for the petition doesn't request of the counsel for the response. The purpose of filing reply.
May I request in the motion list, my lord.
Counsel for the petitioner. I'll say 16.
16 in the motion list. I'll serve the reply affidavit even before that. Obliged.
16, yes. That is in the minutes. Suppose I can. This is a.
Item 39. P. Subhash. Gadi Praveen Kumar, Deputy Solicitor General of India.
Yes. What is the interim prayer you are seeking? How can this prayer be granted? What is the interim prayer you are seeking? Yes. Page number?
20.
Yes.
Dated 30/9/2023. It is 17 hours. Hyderabad Post Office. Item on hold door market intimation. Finally, your lordship on I-10/2023. What said? It has returned insufficient. These cannot be possible when they can able to serve the notice to the respondent on 30 days, identifying the house address. They cannot return the article saying that address is insufficient.
Will direct. Will direct the second respondent to consider the representation dated 6th October 2023. Yes. Yes. What does the inquiry say? Yes.
Is made of the case between the of 39/2023 and the same day they were issued the comfort postman. The postman did not find out the locality that is LIC Colony and kept the letter in office. But the inquiry 39/2023. On 3/10/2023, the letters were again issued to the same postman. What is the identity was considered quality. On the inquiry at the locality found that there is no such house number in the corner. Since the said articles were returned to the postman with remarks insufficient address, returned to the sender on 3/10/2020. Further, the concerned delivery postman stated that the rush of post erroneously yet unintentionally written as door drop instead of insufficient address for inquiry of 39/2020. However, the concerned official did not repeat such instances.
They are the articles. They are the articles containing the market notice. They are admitting that they have committed the part of your lordship. Even the reply filed before your lordship is filed by them without considering me as a party to the inquiry. Unilaterally, they have conducted inquiry. They have produced the letter before your lordship. My full submission to lordship. My representation may be disposed newly following due process of law, giving me an opportunity to submit my case before the authorities.
They are very clearly saying that such a number, house number doesn't exist at all. Have you given him a copy? Given a copy? And and it is by mistake, it is written as do not instead of insufficient address. Kindly look into the instructions for a second. It's not that they did not act in pursuance to the representation given by you and after notice has been ordered by this court. They have undertaken the exercise.
One point to be observed here is
Yes.
there are several similar responses by the courts or authorities.
Yes.
The other persons cannot come to this court by way of filing repetitions.
Yes.
So this fact is not to the action notice by filing this petition. They cannot simply say that it is by oversight. My submission, it is a clear act of professional misconduct on the part of postman as well as the his superior officers of postmaster. They cannot escape from the liability saying that by oversight. Some action has to be taken for the misconduct. So that it will not be repeated in future.
Repeated action also has been initiated. Kindly see the last line. Warning is not enough. You believe in punishment?
Yes, Your Lordship.
I believe in pardon.
No, Your Lordship. My submission may be taken into consideration before taking any
Yes,
action.
already action has been initiated, right? The petitioner approached the court sitting for prayer as under extract the claim. The learned counsel appearing on behalf of the appear for exponent 1 to 4 brings on record written instructions which read as under extract. The learned counsel appearing on behalf of the petitioner submits that there has been lapses in the discharge of duties by the postal authority and therefore they need to be punished. Case resolution. Last paragraph of the written instructions dated 8th November 2023 indicates that the concerned official has been suitably warned not to repeat such instances of negligence in future. Taking into consideration the aforesaid facts and circumstances of the case, the writ petition closed. Yes.
Item 40. P. Srinivasa Prasad. We due money.
Yes.
Again, the RBI the bank had initiated NCLT proceedings under Section 6 way back in the year 2018 against the company owned by the petitioners, which they were directors. Not a whisper was made about the petitioners being declared willful defaulters, and in fact, for an entire year, my lord, they had started on resolution proceedings before the MCLT, which was later set aside by NCLT and reversed by the Supreme Court. And it was only in the month of October, 26th of October, my lord, when a one-time settlement was proposed, that the bank simply gives a scanned copy of an alleged publication, my lord, to the petitioner, stating that they are willful defaulters, therefore we cannot look into the one-time settlement. I'm told, my lord, now a liquidation order has been passed. I have also filed at page number 45 of the petition, and I've been instructed that the liquidation value of the company is much less than 20 crore values. But the OTS is at least twice of that liquidation value they have offered. And the only thing that's coming in the way is this order of willful default, which was allegedly passed and published in the year 2019.
It's let them file a counter. 16/4/2019 is the
It's not the notice, my lord. The notice should have been much prior to that, but my entire contention is that notice was never served on me, madam, which is against the RBI circular. On the face of it, I'm able to show to you, my lord.
It's not without a counter.
But
who appears for the respondent?
In fact, the entire writ petition copy along with the paper was served on the court itself, my lord. The only difficulty, my lord, I'm only trying to canvass before my lord the balance of convenience, my lord. Because if this order is not already 4.5 years has been out of the financial system, my lord, and no bank is going to give me even a single rupee in loan, given that this publication was allegedly made in the year 2019. The only benefit, my lord, is to the bank in the present case, because the one-time settlement is at least 2.5 times of the liquidation value that they will receive, my lord. And in fact, this representation I'm told was made before the NCLT also. And given the difference in value of the one-time settlement and the liquidation value, NCLT has also adjourned the matter by 2 weeks, so that the bank will have some breathing time to consider the one-time settlement if the order of willful default is suspended by the court. I'm only seeking interim suspension. I do not get any benefit from the interim suspension.
You have referred to some earlier orders of the court, page?
My lord, there is an earlier order, my lord, page number 83.
Under similar circumstances?
Similar circumstances, my lord. In fact, another which my lord, where the value of the note itself was 840 crores. And there was a notice served, but they did not have an opportunity to present their submissions matches. And even then, this honorable court held that since there's a fundamental right of the petitioners that's been violated, it set aside the order declaring the petitioners there as willful default. And even these orders, my lord, page number 83, they were passed in similar circumstances. The challenge was that no notice was given, interim suspension was granted by this honorable court. May be permitted to pass on the 2021.
That notice pertain to the year 2023, where this court passed interim orders pertain
in those cases
pertain to March 2023, February 2023, and orders are passed by this court in the year 2023. You are referring to the notice of the year 2019.
But may I pass another judgment? Yes, the notice was the year 2012.
2012, but certainly after hearing the respondent counsel.
So, there was an interim order passed as well, which I was page, page number 8. Yes. At paragraph number 6, the interim suspension of classification of the petitioners and willful default was ordered by this court on 1/9/2021. This was a matter that 840 crores was given by the company of the petitioners there in matter. And they were declared as willful default. In fact, the company was even declared as a fraudulent company. There was an FIR filed, there were charges that were filed, and companies were also initiated.
Have you complied with the order of this court dated 1/11/2023? Have you complied with the order of this court dated 1/11?
Yes,
where is the memo?
I have filed proof of service matter on the
When have you filed it? And what is the SR number? The SR registry to verify and stuff. Memo dated based on 15th. Yes. 15th. Let us see. In the meantime, any counsel?
Apology,
No, not secondly, not hearing the counsel. 2019 is. Let us see. Give them some breathing time. 2019 is the notice. Yes.
In fact, even that, the copy of that publication file that was served.
Let us see. Matter of 2 more days. Yes.
The problem is
list on 16th. 16th. Yes.
At least 2 sides of liquidation value can be realized in the bank.
List on 16th. Yes.
Item 40, item 41.
16th. Yes.
15th.
Bendy Sai Santosh. Special.
May I please, Your Lordship?
Yes. List on 15th.
May I please, Your Lordship?
Yes.
Your Lordship, the present petition has been filed for release of documents which are mortgaged against loan account of the group of petitioners, Your Lordship. On the last occasion, the respondents have seek time for getting instructions, Your Lordship.
Yes. Order of this court dated 13/7/2023 under similar circumstances. Yes, who appears? Who was the counsel who appeared last occasion?
Lordship, counsel for respondent number 3, Your Lordship.
Yes.
Respondent number 3, Your Lordship. The last occasion, the counsel for respondent number 1 and 2, the bank's counsel has been appeared, Your Lordship, and have seek time for instruction, Your Lordship.
Yes.
As per my client's instruction, Your Lordship, my client has received a phone call from the bank.
Yes.
Seeking information of the documents, Your Lordship.
Yes. The name is not printed in the list.
Special PP for CBI, respondent number 3 is what is printed in the list, Your Lordship.
But who is the counsel for the bank? Counsel for the bank is? You appear?
On the last occasion, they have appeared, Your Lordship.
It's what do you say? Insofar as the order at page 28 is concerned.
Any company is the in charge to know the name. Not aware about the names. Any date after the Tuesday.
Bank counsel is. Who is the bank counsel? IDBI Bank. Yes, friend. The counsel for the petitioner is permitted to take out personal. Yes.
Much obliged, Your Lordship.
Counsel for the third respondent is.
Specially identified cases. Item number 43. Arrangement in Chillola, Ramchandra Gaur, VC Ravinder Reddy, GP for Civil Supplies.
We are seeking the time just in order to get apologies identified things in 1 week. Full matter your short time, but
Yes, friend. Request for the counsel for the petition. Forty-three, my lord. 42 42 morning HNA. Extension of India. 43, 42. 4. This one. 20. Yes.
Item 46. S. Niranjan Reddy, Vadi Praveen Kumar, Deputy Solicitor General of India, GP for Medical Health, Family Welfare.
Yes, thank you. Learned counsel.
Item 47. Syed Mohammed.
My lordship. I'm sorry, my lordship. Item 43 to 45 not called, my lordship.
They have been called and they have been adjourned.
Oh, sorry, my lordship. Much obliged, my lordship.
Adjourned to 2011. Adjourned to 28th.
Much obliged, my lord. There is already infractions matters, my lord. That is, there is no cause of action survived, my lordship. Obliged, my lordship.
Counsel for the response that the counsel for action does not survive for adjudication reports. Request for orders. Move for orders. Yes.
Item 48. A. Suryanarayana. 48 and 49.
These two matters.
December 2019.
These two matters have to be heard. These two matters have to be heard.
I have tried case number 1 of petition. This is for choosing the property from the petitioners to
make one submission, right? This petition is in the nature of execution petition. It is akin to that of litigation, finding civil proceedings by the civil court. Last week, I see the orders are to be implemented has become final and binding up to the Honorable Apex Court. It was confirmed even up to the stage of curative petition that was held by Lord. Yes. The order to single judge passed this order way back in '83. And till today, we are unable to read the benefits of this order despite contempt show cause notice against the respondent cantonment court. And some people will come and say that they are having interest in the property and they want to sell as respondent. If they are really interested in the property and if they claim title from me, they should have joined me as the petitioners, or they may maintain separate petitions under 226. Now, because of the simple petition, the scope of the petition cannot be enlarged by that. And by virtue of any measure, this order remained final up to the Supreme Court and cannot be even.
You are opposing the implead?
Yes, ma'am.
Have you filed your counter opposing the implead?
May morning only this somebody copies to me.
Yes, I'll
post. That is a separate issue. Yes. If the petition will be kept pending, now it is for 34 years litigation, long-term litigation. Till today, but permission of the compound wall is not obtained by the petitioner. That is the situation. But Markery of Justice filed.
You file your brief counter to the template.
Will
dispose of the writ itself. Yes.
Let the writ petition be pending for years together. Let them, any party may come and seek implement, propose of respondent or petitioner. I am not bothered. I will file counter and according to law. But as far as the contempt show cause notice is issued, it has already been initiated by the Honorable Court. That cannot be kept pending, my lord. Since 2019,
contempt is not listed.
Contempt show cause notice was issued by the Lordship was Secretary Ramchandra Rao in the month of December 2019.
But I think a separate counter line the document evidence.
Yes.
Yes,
let us see that. Yes.
At least any order is invited on the contempt show cause notice.
After this, the losses are not initiated any further step. You are directed to file counter according to the counter. Put all the factual aspects regarding registration of the application long back and submission of fresh application to all the plot holders and for seeking a layout on the same property. And that was also returned to certain locations. Thereafter, they are not submitted the application. I tried to get copy of the representation submitted and other written of the application to the itself.
Yes.
I predict that the readings are to be implemented cannot be frustrated or modified by the Supreme Court because it has attained finality of the Supreme Court.
But it's not my submission not he has sold the property in 1995 itself. There are no locus standing before this Supreme Court at all.
With regards to the same delivery, we have already filed two different petitions which are already going. WP number 173 of 2023 and WP number 29750 of 2016. Same parties for the same level.
Let them file any number of petitions, advocating their rights to us.
You file your counter to the implead, your objections to the implead, we'll dispose of the writ itself. Is that list 46 and list 48 and 49? List on 60. Yes.
Forty-seven filament. 47 filament. 49 mirror. 50 ఉంది కదమ్మా 50 ఉంది ఈ అమ్మాయి ఏంటని చెప్పు
47 item 42 to 40.
council interrupted. Cause of action does not survive for adjudication anymore. Please don't control action supplement.
47
Right.
Item 47, ఆ తర్వాత 50 పిలవండి.
Item 47. Syed Mohammed Nizar Mohyuddin. A. Ramakrishna Reddy. Partner matter item 50. S. Pradeep Kumar, Dominic Fernandez, Standing Council for IOCL, GP for Civil Supplies.
I am here for respondent wanted to allotment may kindly pass over to the council.
Paso? Yes. Paso. Soon after lunch motions and pass. So, no lunch motions. Last one. Okay, any lunch motions? Which lunch motions? First. Which one? Listing? Tomorrow. Can you make a mention at 2:30? I'll accept it now, but hereafter don't repeat it, not only in my court or any other court. Make a mention only at 10:30. Yes.
Lunch motion, item number 1, Ms. Rima.
This is the second round of.
Yes.
Which is at page number 28, the earlier round of application, page 28.
Yes. Yes.
The minutes of yes, this was not directing the respondent to consider the representation of petitioner dated so and so and pass appropriate orders within a period of 4 weeks from the date of receipt of this order. Till then, no steps shall be taken regarding allotment of dealership to any third parties. In the event of passing any adverse order, the respondent shall hear the petitioner by offering an opportunity of hearing, if not already decided. This is protecting the interest of the petitioners and also not allotting the dealership to any third parties.
Yes.
Thereafter, minutes, the Deputy General sends addresses a letter to the petitioners to come for a hearing, a personal hearing. At that point of time, petitioners was not available. He replied to a letter stating that I'm not in India, therefore grant me 6 months of time of personal hearing. And thereafter, time was granted. Subsequently, time was extended. He has shown interest and been communicating through letters addressed to the respondents, which are at page numbers 31 minutes.
Yes.
Showing his interest after calling for an opportunity insofar as the earlier writ petition is concerned, he has addressed an application to the respondents to save his interest, and after the allotment made to the petitioners in the year 4, on the date of 4/1/2001, they addressed a letter that yes, we are going to allot you a dealership, which is page number 17. This was the subject matter of the earlier writ petition also. Page number 17 minutes. Issuance of service provider and dealership. With reference to your application dated so and so with us for HPCL, service provider and dealership, we are obliged to inform you that we are hereby offering you the service provider and dealership of our company for the site and survey number so and so, Bhimgal village, Nizamabad district, located on Bhimgal Murga Road, starting from April 2002. Since the issuance of this letter, there is no dealership allotted to the petitioner, and subsequently, the first round of litigation, the petitioner succeeds protecting his interest and not being allotted to the third parties. Now, at this juncture, after the filing of the present writ petition, also, it has come for hearing thrice. The respondent sought time for instructions and no counter is filed. And subsequently, we have sent notices to the, may I kindly pass on the notice addressed to the respondents, which is dated 14/12/2022.
Issue a very short one. Justice Gau's order, Justice Amarnath Gau's order at page 28, which my learned friend has read at paragraph 4, page 28.
Yes.
There is lordship, by noticing the fact that service provider should issue requires his representation considered and him to be given a personal hearing, directed us to give him a personal hearing. So we have been repeatedly asking him to come to us, come and tell us what the issue is and all these aspects. We will give him the hearing and thereafter, and his lordship has also protected his interest by saying no third party interest will be created. So far as what that concern is there given to, but the problem is since 2019 he's not coming to us. And he addresses letters for saying that I'm stuck in USA and due to visa problems, I'm not able to come. Now we have to run the pump. So what we did is we took it up as a COCO dealership, that is company owned, company operated dealership, because he's not coming. And we are running it on an ad hoc basis. The instructions, Malas, I may submit. If he were to come to our office tomorrow also, we resolve this issue. Instead of that, whereas this litigation is unnecessary because he can come to us. We have repeatedly been asking him, please come. Well, Lordship, please see these letters which were given to him.
I have filed them so far as the material is concerned. Because they have.
Yes, when can you go before the authority?
Within 1 week, I can go to one. I have only one submission. I have sent I can take over 1 of 23. On the ad hoc basis as submitted by the learned senior counsel, they are going to conduct interviews tomorrow for the reasons of this ad hoc appointment to third parties. That is my submission. May I be permitted to go tomorrow and let third parties not be entertained? I'm grateful to your Lordships.
You cannot appoint third parties because your Lordships have said, let no third party interest be created. Perhaps with the reason to create an urgency before this court, petitioner may be telling my learned friend that reason. That is not the case at all. We will entertain him, let him come to our office and we do the deed. As for appointing ad hoc, don't do interviews. We appoint persons on an ad hoc basis. There are some rules governing appointment of ad hoc basis. The company cannot run a dealership itself.
How far is this ad hoc appointments? The period for ad hoc appointment
on a yearly basis.
Yearly.
Since 2019, these communications are being given to him, and he keeps sending letters. No, I'm not saying he has a visa. He may have a visa problem. But the point is, since 4 years, these things are going on like this. So let him now. I believe he's in India. If he's in India, let him come.
Senior counsel, this opportunity we provided to this petitions to appear before the organization within a week. And the letters can be observed.
Those letters from him are repeatedly saying that letter, for example, says that I'm not able to come because of visa problem.
What happened for the period from 2019 till 2023? How was that?
How was it that since he was not coming?
It was the bank was not in operation
on an ad hoc basis. So yearly basis, we appoint someone, we tell someone to take it up. Now what has happened? Because
you decide the issue itself. Where is the need?
Within 1 week, whenever tomorrow.
Yes, right.
It has been running to third parties. I have given these to them. It should be allotted to me. Therefore, given the original letter in 2012 that yes, you have given these for 30 years in your land. Therefore, we are going to give you service dealership. That was the agreement entered between the HPCL and the petitioners. Then after the lease deed is entered by the petitioners, they have given me this letter of issuance of service dealership.
Yes. Yes. Petitioner urged the court seeking to clear as and extend the case. Not the learned counsel appearing on behalf of the petitioner and learned senior counsel Mr. Mayur Reddy appearing on behalf of respondents.
There's only one.
Respondents. That was the record. It is the specific case of petitioner that and earlier patients approached the court. Filing rate petition number 352 2016. Supporting the action of the respondent hearing in not issuing the service provider and dealership to petitioner is ensured by letter dated 4 January 2012. And considering the petitioner's representations dated 1/5/2015 and 27/1/2016 as illegal, void, and arbitrary, and to direct to issue service provider and dealership as issued by letter dated 2012. In the interest of justice, the said petition filed by the petitioner dated 23rd April 2019. Petition number 358/2016, filed by the petitioner, was disposed of on 23rd April 2019, observing as under extract paragraph 4. This is the specific case of the petitioner. Due to certain circumstances beyond petitioner's approach the respondent hearing, but however had been communicating with the respondent to representation dated representations explaining petitioner's difficulty in attending the personal hearing. And now the respondent is proceeding and facing steps with regard to allotment of the dealership to third parties in respect of the outline located on Velpo Road at Greengun, PHEMGA. And agreed by the same, the petitioner approached the court by filing the present application. The learned senior counsel, Mr. Mayur Reddy, on instructions, submits that though the order of this court is dated 23rd April 2019, the same could not be implemented because the petitioner never came forward. Yes. CC today. Yes.
Item 2, lunch motion. Mama Dadna, B. Satyam Reddy, GP for Revenue.
But it's called extension by 4 weeks. We have to get some certificate copies from the today, the time outside. Extension by 4 weeks.
It is coming up for the extension of interim or regular, which has expired on 7th of this month.
Yes. Counsel for the petitioner is present. Interim board of the grant of 2023. Extended till November 23. Mr. Karkeri. List. List of meeting. All the direct has been filed as on date of the bank. Notice of with response as on date. Yes. Yes. Nineteen. It's to 19th. Extended to 9th December. Yes.
Password matters. Item 22, Ravi Kondaviti, B. Nalin Kumar.
Yes. Yes. Any counter has been filed?
Yes, the counter is signed by the board. Not receiving copy from her.
Then you go through the counter. What do they say in the counter insofar as the interest aspect is concerned? Go to that. Yes, right. Counsel for the petitioner is present. No representation on behalf of the respondent and the case is for. So, when do you want it? Stone 17. Take the copy.
Sure.
Take Xerox and give it back without fail. Yes.
Part-head matter, item number 50. Password matters. Yes, Pradeep Kumar, Dominic Fernandez, Standing Officer for IOCL, GP for Civil Services. Civil Supplies.
Yes. Yes.
Yes, to me that they are trying to say since they have already filed a counter, that is my action.
The counter clearly says that we are not available in a partnership the MOU page 15.
Page
151.
Yes.
Page 15 of the counter that shows the MOU file.
Page 15 of the counter.
Yes.
What is? Yes. Page 15. Yes.
Page 15 of the counter that shows the MOU between the and the petitioner before the lordship.
Yes.
My lord, your lordship, you see page 17, my lord, where it says the first party is not entitled to withdraw, resile, or revoke the agreement, sections of the contract, and the first party has no option to terminate this agreement as the same is executable for consideration.
Yes.
Furthermore, my lord, after this appointment was executed without the permission of IOC, my lord. Further, they have even executed partnership agreement without IOC's interference. My lord, there is a letter, my lord, complaint received by Prabhakar, who is allegedly the partner on 30th September 2020. My lord, brief facts of the case are, my lord, in 2008, the form license was submitted irregularities found in the investigation conducted, my lord. To get out of those irregularities, the petitioner using category 9 lakh rupees as fine, my lord. Ways to pay that 9 lakh rupees. In fact, the petitioner herself has written a letter, my lord, to IOC requesting us to appoint the Prabhakar as a partner. However, at that juncture, we have only written to the state supply authorities for revoking the formal license because there was a petition filed before this honorable board. My lord, post that, my lord, there's a policy in 2020 that allowed for regularization of partnership agreements. Now, the distributorship agreement said that the distributor is not permitted without the permission of IOC to sell out the share or to dispose of the shares without the permission of IOC. However, in light of the partnership agreement being executed between the petitioner before the lordship and the other private party, we have given them an option of regularizing the partnership agreement, my lord. Only one option was given, such regularization policy. We in fact wrote a letter at page 38 of our outer affidavit, your lordship may see. Page 38, my lord. Page 36 of the letter starts, where we have given them the option of regularization, my lord. At page, your lordship may see, your lordship permit me to read from paragraph from page 37, my lord.
Yes.
Mrs. Leela Gas Agency was inspected by Assistant Civil Supply Officer Kamareddy on 22/9/2020, and the PCA case has been booked against the distributorship for violation of clauses 3, 4 of the Liquefied Petroleum Gas Regulation of Supply and Distribution Order 2000. Based on the proceedings of Collector CS Kamareddy by so and so dated so and so, the operation of your distributorship was suspended with effect from 23/9/2020 till further advice by letter dated 22/12/10/2020, my lord. Further, it goes to say how she filed a writ petition, my lord, bearing writ petition 17426, and after which the supply of cylinders was restored, my lord. Further, my lord, this office has received a complaint dated 30/9/2020 from Shri Prabhakar, stating that, my lord, this is crucial, my lord, stating that you had entered into partnership with him in the distributorship with 49% share. This can be seen even in the partnership agreement as well as the MOU, my lord. The complainant has also enclosed registered MOU and power of attorney and unregistered partnership deed executed between you and Shri Prabhakar on 17/2/2010 and 29/3/2010 respectively. Moreover, while your letter dated 19/10/2020, wherein, my lord, you have specifically mentioned that due to your son's medical condition, you have given power of attorney to K. Prabhakar for making all transactions pertaining to Mrs. Leela Gas Agency. Further, while your letter dated 19/10/2020, you have also requested us to continue the agency as proprietorship in your own name. My lord, the complaint has been taken up for further investigation, my lord. In this regard, we draw your attention that these are the clauses based on which we have terminated them. In this regard, we draw your attention to clause 23C1 of LPG Distributorship Agreement 1/4, which clearly states as under. My lord, clause 23, my lord. Except with the previous written consent of the corporation, which is not there in our case, the distributor shall not enter into any agreement, contract, or understanding whereby the operations of the distributor hereunder are or may be controlled or carried out and or financed by any person or company, whether directly or indirectly, and whether in whole or in part. My lord, further, thus, upon perusal of the said complaint and documents cited above, as annexures 9, 10, 11, and 12, it prima facie appears that you have committed the violation of clause 23CI by entering into partnership with third party without seeking prior approval from the corporation. My lord, at this juncture, my lord, you will voluntarily accept the allegations made against you in the said complaint, and we rectify and regularize the said violations in line with which came into effect on 1st July, provided under clause 5, and more particularly provided under clauses 4.5 and 4.6 of the said guidelines. Your Lordship is going to read the guideline number 4.5.
Yes.
Condoning of cases of change in constitution done without OMC approval. This was a one-time offer that we had given to all distributors throughout. In case of any change in constitution done without prior written approval of the OMC coming to notice the revised setup, if otherwise meeting all conditions or criteria related to reconstitution, may be condoned or regularized, subject to the distributorship paying the specified ratification amount to be fixed by OMC. Such ratification amount shall be above the applicable reconstitution fee. Such cases will be dealt as under 5.1. Constitution is currently in line with approved setup and past deviations have been rectified, which was not done in our case. We had given it an option in 2020 to rectify the error of entering into agreements without permission of IOC. However, at that juncture, she chose not to take that option given to her. These are cases where unauthorized persons had entered into the distributorship or operated the distributorship fully or in association with the proprietor or partner by entering into such agreements. However, the distributorship has rectified or requested for rectification of the mistake and reverted to last approved setup. Such actions can be condoned by OMC on one-time basis after taking a suitable undertaking from the distributor, requesting condoning of the past actions, confirming understanding of the provisions of the agreement for compliance in future, and issuance of letter of warning by OMC. Such distributorship would be required to pay ratification fee of Rs 2 lakhs or gross distributorship commission on highest 2 months lethal sales in preceding year, plus applicable GST, whichever is more. In the absence of payment of such ratification fee, the OMC shall be authorized to take appropriate action against the said distributorship, including its termination. My lord. 4.5.1 following page. Proposed constitution requires recognition of induction of an outside partner in the past without approval of OMC. In cases where distributorships have inducted outside persons, which was the case in our case, partners without taking approval from OMC. Upon request from the distributorship, the proposal would be considered for approval. Upon reconstitution, the distributorship would have to pay a ratification fee of Rs 5 lakhs or gross distributorship commission on highest 4-month retail sales in preceding year, plus applicable GST, whichever is more. In addition to applicable reconstitution fee, and OMC would issue a letter of warning. In such cases, the proprietor or partner operating the distributorship would make an application indicating complete details of the case and requesting for condoning the past actions and confirming to abide by the provisions of distributorship agreement in the future. The proprietor/partner would also be required to submit complete proposal for induction of the outside partner upon request from the distributorship. Such proposal would be considered. The proposal received from the distributorship will be scrutinized by the area or territory or regional office in charge and to a 3-member committee constituted, nominated by the state head, regional head, or zonal head. Recommendation of the committee should be forwarded to the state head, regional head, zonal head for final decision. New distributorship agreement will be signed with distributors subject to approval by state head or regional head or zonal head and after taking suitable indemnity from the distributorship. However, upon reconstitution of distributorship would be warned by issuing a letter of warning. Now, you can see page 49, the last portion, the detailed paragraph, second paragraph from which I'm reading here. The detailed guidelines for reconstitution. This is the one that I told you that I submitted in 2020 to reconstitute. The detailed guidelines for reconstitution have on LBT distributorship, which came into effect from 1st July 2020, have already been conveyed to you by emails dated 14/7/2020 and again on 13/5/2020. Our field officer has also sent you an email to you on 19/10 in this regard to submit your application
for reconstitution, question before 31/10/2020. I'd like to make a submission, my lord, where after the complaint was received in September, my lord. After the complaint was received, we have given her an indication informing her that once your complaint is filed, you will have an option of reconstitution under the guidelines. Please avail that facility. However, my lord, she has not availed the facility, and your lordship must kindly consider that only after 31/10/2020, my lord, when the option of reconstitution was prevalent, only after that period expired, we have taken action upon the complaint received. And the complaint received was stating that she executed MOUs and partnership agreements without permission of privacy, which is not permitted. My lord, your lordship, you see, in view of the above, you are advised to submit application for the rectification and regularization. This is the letter my lord that we sought, saying we have brought to her notice, these are the violations. We have told her that these are the complaints. We have even attached the documents given to us, and we have told her kindly you are advised to submit applications for rectification and regularization of the arrangement made by you by inducting partner in the distributorship without approval from this office, which is a fact, my lord. By paying an application amount over and above the applicable reconstitution fee in line with policy guidelines, you are hereby advised to submit your proposal in line with the said guidelines or before 31/10/2020, failing which such action shall be taken as per the provisions of the distributorship agreement, including termination of distributorship as per company corporation's policy. My lord, this is part of the letter, my lord. Following which, my lord, there is another letter in 2020, my lord, after this letter. That is at page 41.
Yes.
My lord, this is because she did not avail the reconstitution policy, my lord. This has reference to your acknowledgement by letter dated 27/10/2020 for confirmation of our receipt of our letter dated 22/10/2010, wherein we advised you to submit application on or before 31/10/2000 for rectification of the arrangement made by you by inducting partner in the distributorship without approval from this office. We have not received application from you for rectification of the arrangement made by you by inducting partner in the distributorship without approval from this corporation. We had also forwarded a copy of the complaint dated 30/9/2020 received from Shri Prabhakar, son of late Mayor, along with our referred letter with all supporting documents. You are advised to send your reply to our letter in which the complaint details are mentioned within a week from this date, failing which action shall be taken as per guidelines stipulated in the corporation's policy. My lord, your lordship can appreciate this is letter dated 5/11/2020. My lord, following this, she written a letter dated 9/12/2020 at page 42. My lord, she has stated that your lordship may permit me to read the letter.
Yes.
I am to request you to kindly consider the following few lines for your sympathetic action and favorable orders, please. The complaint has been lodged against A. Prabhakar for his forgery of my signature in getting all the records pertaining to the business of Messrs. Leela Gas Agency in his favor in connection with the complaint which had been lodged in Banswara Police Station. The FIR 233 of 2020, Amur Police Station and Nizamabad Town Police Station, in spite of which no action was initiated against K. Prabhakar, is no more a member or partner or GPA holder in our business, i.e. Mrs. Leela Gas Agency. IOCL has accorded permission for shifting the office showroom to a new premise. My lord, this is also crucial. This is another aspect of the issue. But the new premises could not be registered due to ban influence on the registration by the government of state of Telangana state. The registered lease deed will be submitted after registration office opens. I shall assure you and understand through affidavit that the registered lease deed will be done without fail and the concerned documents will be submitted accordingly as soon as the registration with the changed premises. The other documentation she says change is member. And she requests for to issue a duplicate or original return back to me from K. Prabhakar, the change of new premises. Further, I also request you to kindly supply the duplicate of allotment letter. She has no documents for her. The duplicate of allotment letter and distributorship agreements. The whole office keys me as the original letters of above cited matter have been taken away by K. Prabhakar, and the old office is locked by him, and thereby products which were brought to old premises of Mrs. Leela Gas Agency could not be delivered as an alternative. The products have been delivered to some other premises as a stopgap arrangement. Therefore, I am enclosing herewith the following documents and showroom photographs as per IOC guidelines. Finally, I most humbly request you to kindly see that IOCL records pertaining to Mrs. Leela Gas Agency may be entered as per the changed premises. My lord, the following about this, then after this is done, my lord, there was irregularity and then there was again suspension that took place, to which we have transferred all the products to a neighboring gas agency, my lord, which is receipt at 44, page number 44, my lord, may see. As per the proceedings of the collector, Kamareddy district by order dated so and so, directed Mr. Radha Krishna, Mrs. Vicky Lane, to hand over stocks and records which were based on 20. So, my lord, we see for 2 years the stocks were with another distributor, my lord, and he was handling the distributorship.
Yes.
My lord, following of which, your lordship may see, my lord, the Leela Kumari is a party signatory to this document at page 44, where she is aware. And even at page 45, my lord, your lordship may see there have been some discrepancies to which the go down stock was allotted for another for easy reference and easy functioning of the distributorship. Attached by the minute, further one of the conditions was the show cause notice / the termination letter were not delivered to her. Your lordship will see at page 48, we have sent the registered post and it was delivered to her on 36/2022, madam.
Yes.
She writes that to us, my lord, after we have written to her show cause on 3/7/2022. Your lordship will permit me to read at page 49. With reference to your letter, so please acknowledge the receipt. So she has received, my lord, 27/6 annuity in her letter dated 3/7/2022. With reference to your letter, Leela Gas Agency has written to IOC, my lord. In the first paragraph, she's acknowledging receipt of that letter, my lord, dated 27/6, which is the improved letter with her lordship. Please acknowledge the receipt of this letter and extend cooperation by being present shown. This was what we have said. The cited already we have handed over to Mr. Ravi Mohan Reddy and physically stored in copy enclosed. Further, all records and original certificates are stolen by Mr. K. Prabhakar. We have lodged complaint against him. It was informed and submitted to IOC State Officer, Hyderabad. Your Lordship will see, instead of resumption, I have now been given termination letter, which has come under the shock. I am ruined and joined in hospital getting treatment. I did not come to showroom and go down. This is called fact information. My lord, following latest is 26/4/2022, which is the press decided to hand over stocks back to Leela Agency because of a writ petition filed, my lord, and that writ petition is pending. My lord, in that writ petition, my lord, it's crucial to place to record that there was no mention of MOU or the power of attorney or partnership deed executed by Prabhakar. It was only a case filed by the petitioner against the collector for revoking of Form B license, and that writ petition being pending has no bearing on our termination letter, which was our termination letter. Detailing lays down the contravention of provisions based on which we have terminated her. Your lordship may finally see, my lord, as your lordship may see writ petition, my lord, for a moment.
Yes.
They claim that one of the submissions of the writ petition, my lord, is that IOC has forced her to enter into partnership agreement, and IOC was well aware from the very beginning, and in fact IOC has introduced her to the partner. Is the claim, my lord, watch. We see page 59 for a moment. Based on this letter, we have encouraged her to enter into partnership.
Your Lordship, may permit me to just read one paragraph of this letter at page 59.
Yes.
Well, this is 21/7/2010, my lord. This is the initial revocation, my lord. Your Lordship, may recollect I had initially submitted that in 2010 there were some irregularities and formal license was suspended. Against that suspension, IOC has written a letter. Your Lordship, may see it's crucial to the district collector. Only for resumption of sales, your Lordship, may permit me to read this letter, my lord. Subject: revocation of non-meal license of Mrs. Leela Gas Agencies, Banswara. We are having a distributorship by name Leela Gas Agency in Banswara, and their form B license has been suspended by you. My lord, the proprietress's name is Mrs. Leela Kumari. The agency was not managed well by Mrs. Srimati Leela Kumari due to financial problems. My lord, this is crucial. She has paid the dues to IOC and wants to, she wanted to develop a judge juncture as well, and wants to induct one Sri Prabhakar as her financial partner. Based on her letter requesting us to induct Sri Prabhakar as her partner, we are processing her request for induction of partner. That is all we have said about. There are no junctions. We have initiated that partnership, nor have we introduced them to each other saying, let him help you out. That is not the case, my lord. The brief submission before your lordship, my lord, is at this juncture there are a lot of questions of facts before your lordship, my lord, that needs to be ascertained, my lord, and there are a lot of contradictory factual aspects that have come before your lordship. For example, my lord, initially 2010 formal license was revoked and then it was suspended and revoked. After which, allegedly, Mr. Prabhakar has been continuing as a partner. However, on record of IOC, it has always been a proprietorship firm, or distributorship firm has always been a proprietorship concern, has never been a partnership. Upon getting to know about the partnership, after this and at a later stage, due to the complaint of Mr. Prabhakar, we have given her an option to rectify the mistake because of the policy prevalent at that point. We gave her an option. Say if you rectify the error, we will use you as a partner. However, my God, after we give her an opportunity to induct, she goes back on her word and says, now I don't want the partnership. All the partnership agreement is fake, and all the documents executed by me have been forced by me, and nothing till now, whatever facts we have come into appreciation are not true. And she says that please let it be a proprietorship concern after the complaint is received. Based on these allegations, my lord, and your lordship may finally permit me to take your lordship to termination, my lord, to show that it's a recent order. My lord, termination agreement, it's at page 18 of the writ petition.
Yes.
Oh, your lordship, we see the first few paragraphs talks about the allegations. My lord, specifically from page 23, my lord. Lordship, we see on examination before paragraph 1 on page 23.
Yes.
So if you lordship may appreciate, first 5 pages are issues and facts. From page 6 onwards, on the internal page numbering at page 23, is the observation of corporation. Your lordship, allow me to read this as on your lordship, page 23.
Yes.
Yes, my lord. On examination of the show cause notice dated 3/6/2021, your show cause replied 16/7/2021. Submissions made during personal hearing dated 18/8/2021. So personal hearing also was accorded, my lord. And then presenting documents and on production of the same following are our observations of the corporation. Point 1. These are the 3 facts according to the corporation. That you are operating the Indian distributorship under sole proprietorship by distributorship agreement dated 1/4/2006. While the distributorship was operating, the same was penalized for shortage of 434 cylinders and 51 PRs during inventory check. You have stated in your show cause reply that since you were finding it difficult to pay the penal amount, you have inducted Sri Prabhakar by entering into MOU for managing the affairs of the business. It is denied
that IOC officials have suggested you to induct the partner to get out of the financial mess, and the call rests with the distributor either to operate the distributorship on sole proprietorship or its partnership. Nevertheless, any change in setup of the distributorship must be undertaken after taking prior approval of the corporation as per the reconstitution policy. In the instant case, MOU and partnership with Sri Prabhakar before approval of reconstitution and without informing the corporation. With regard to your submission that Sri Prabhakar had influenced and pressurized to sign MOU, it is submitted that arrangement made by yourself with Prabhakar was not in the knowledge of the corporation and registered MOU and POA dated 6/4 signifies that you have willfully entered into an agreement with Sri Prabhakar without informing the corporation. As per the records available, your distributorship is under sole proprietorship. See, madam, I reiterate, as per records available, your distributorship is under sole proprietorship. And Sri Prabhakar was never inducted into the distributorship. And therefore, the same was unauthorized, set up, and hence it cannot be said that the induction of Sri Prabhakar was within the knowledge of IOCL officials as alleged by you. It is admitted fact that you had entered into unregistered MOU dated 12/17/2010 and conveyed all your rights over the distributorship, LPG distributorship to Sri Prabhakar for a consideration of 22,50,000 manor. You have also entered into partnership deed dated 29/3 with Sri Prabhakar by giving 49% shareholding in the LPG distributorship without taking prior permission, which was later dissolved on 6/7/2020 after a span of 10 years of operation on the ground that Sri Prabhakar was handling the business, has forged your signatures in PAN card registration, VAT, GST registration, bank account, town registration, other agencies. 5. Later, you had entered into enforcement power of attorney by document number 78 of 2010, dated 6/4/2010, with Sri Prabhakar giving you absolute authority over operations and management of the distribution. These clauses are there in the MOU as well as partnership, and later Sri can take also through the clauses. You allowed the operations of the distributorship for Sri Prabhakar to continue without any objection from 2010 to 2020 and have only launched an FIR by crime number 233 of 2020 on 6/7/2020 against Sri Prabhakar for committing forgery after 10 years of operations. Your act of entering into MOU and partnership deed with Sri Prabhakar is manifest from your letter dated 13/7/2020 to the district registrar Nizamabad for cancellation of the POA given to Sri Prabhakar by document and notice informing that POA issued in favor has been cancelled as his performance is not satisfactory. That is the reason she had used for moving for cancellation. It is again reiterated that the above arrangement was done without permission of IOC and against the terms of the distributorship agreement. With regard to your submissions, that you have put up a request for reconstitution of distributorship for inducting Sri Prabhakar was under process. It is submitted that your request for reconstitution could not be finally processed, and in this regard, you may refer to statement made during the personal hearing dated 18/8, wherein you have stated that you visited the area office where you were informed that Sri Prabhakar was not eligible for induction as a partner. Hence, Sri Prabhakar could not be inducted as partner. Your reconstitution proposal could not be materialized. Processing of your reconstitution request does not give you an authority to transfer your rights over the distributorship to Sri Prabhakar. And only after reconstitution is approved, the distributor can transfer the share or control of the distributorship to the incoming partner. In the instant case, you have transferred the control and the management much before the proposal to the reconstitution, which is against the distributorship agreement. On receipt of complaint dated 30/9/2020, inquiry was conducted, wherein the allegation level in the complaint got substantiated, and thereafter you were given an opportunity by letter reference so and so to submit reconstitution application for rectification and regularization of the said unauthorized setup as per policy so and so of the current reconstitution policy and submit the proposal on or before 31/10/2020. However, you failed to submit the reconstitution proposal despite the letter dated
22/10/2020 was acknowledged by you. In this regard, we kindly note the DGM Secunderabad letter dated where it specifically stated if the reconstitution proposal is not submitted on or before, action shall be taken as per the provisions of the distributorship agreement, including termination of the distributorship as per corporation policy. You were very well aware that further time to submit the reconstitution proposal will not be allowed. But still, you have not submitted the proposal, giving corporation the right to take action as per the policy. My lord, further at paragraph 9 talks about the clauses, my lord. Like your lordship will permit to read one clause, my lord. Clause 21, faithful performance. The distributor shall not sell, assign, mortgage, or part with, or otherwise transfer his interest. In this case, 49% is transferred in the distributorship or the right, interest, or benefit conferred on you by this agreement to any person. Infringe the clause, my lord. Clause 23. Except to the previous written consent of the corporation, the distributor shall not enter into any arrangement, contract, or understanding whereby the operations of the distributor hereunder are or may be controlled or carried out and or financed by any other person or company, whether directly, indirectly, or whether in whole or in part. Now, clause 27 also is from the clear lines, my lord. My lord, you also may appreciate this is the most detailed termination letter issued by the corporation. They have gone into 11 pages, my lord, to lay down the recent order.
Yes.
Your lordship. The applicants permit to submit to
Yes.
your lordship.
Yes.
The contention which I have been canvassing was not that I have been forced to enter, a partnership to be entered, etc. That was not my case, at least that was argued before the lordship. Case boils down to two simple facts and the legal proposition that turns out from that. Number one is, when a partnership agreement was impermissible, according to the terms of the contract or the dealership agreement, which obviously empowers the corporation to terminate the services of the agency, having not done. My contention before your lordship was this amounts to admissible. One. Second aspect is, I don't have knowledge, does not lie in the mouth of the corporation for more than 1 week, because the complaint which formed the impetus for the impugned action itself says that the corporation has been dealing with me, that is the complainant, for the past over a decade. Once that is the case, question that perhaps could be arising out of this conduct would be, does it lie in the mouth of the corporation to say that I will now terminate your contract because you and the partner are not in right terms? This virtually seems to be the situation. This is the reason why, my lord, I was trying to tell your lordship on the last occasion that the corporation cannot act upon a person who himself violated the provisions of the agreement, based that as a basis for terminating the services of the agency. This is one very crucial aspect. And then also the lordship's attention to the judgment of the Honorable Supreme Court, which specifically says that under section 39 of the contract, when you have a right to terminate, but you don't, question of yourself falling back upon that does not arise. Now, my lord, kindly may I just draw your lordship's attention to the agreement for 1 second. Is the corporation so very helpless that they can't do anything? While they read so many things from the agreement, kindly see page 39 for 1 moment, my lord. When can the license be terminated is also one of the factors which they say. 27 clause is very crucial because that talks of the termination.
Yes.
Page number 39, I need that is very relevant for driving home my point. Notwithstanding anything contained contrary to the, contrary herein contained, the corporation shall also be at liberty at its entire discretion to terminate this agreement, or which upon or at any
time, either after the happening of any following of events. One, distributor should commit a delay or breach or default of any terms of conditions, governance, and stipulations contained in the agreement and fail to remedy such breach within 4 days of receipt of a written notice by the corporation in that regard. So, this says if you have violated 23, 27, X, Y, Z, whichever my learned friend read, this provision was available to them. And the judgment rendered by the Honorable Supreme Court in 2022, which I passed on to the Lordship on the last occasion, specifically deals with this very aspect, and it says this. If once you have done a particular thing which amounts to acquiescence or waiver to terminate, question of whether falling back upon your sweet will and pleasure does not arise. This is a judgment reported in Madam 2022. 2022, volume 2, page 25.
Yes.
Yes. This specifically para 19 may kindly straight gone into matter. This is a matter related to contract employment, etc. But that may not be necessary. But the principal part of it, which I am trying to drive home, my lord, you are not to get it para number 19 at page number 37 of the volume.
Yes.
It reads like this, my lord. Section 39 deals with the effect of the refusal of a party to perform a promise only. Though we are not concerned with this provision is only one that speaks of the concept of acquiescence, which could be signified by the words or conduct being an exception for terminating the contract. Under this provision, a promisee may put an end to the contract unless there exists an element of acquiescence that they could be seen and exhibited through their words or conduct. Is to be seen on the facts of each case. So 39 says, if you have to terminate a contract for a breach of a particular thing, and you don't do and you continue to do with that, this amounts to acquiescence or a waiver of your right to terminate. Can this be used after decay? The answer can only be no. And second aspect is, see the complaint filed by that, which is the basis for the entire thing. Can the corporation again plead ignorance of the very arrangement at page 56? This is the complaint. I state, that's how I looked at page 56, part of the complaint itself begins, and this is what it reads. Again, September 2020.
Yes.
I state that from 2010 to 2020, I have been managing the business, placing orders, looking after administration, doing correspondence, filing income tax returns, coordinating with the government, officials of IOCL by virtue of the powers vested in me as per the registered GPA. Now, according to them, GPA itself is not liable to be recognized by them. GPA, the memorandum of agreement is not liable to be recognized by them. The partnership is not liable to be recognized by them because we have not taken a prior offer. If this is their argument, question straight would be, could you or could you not have terminated my services when the first intent was placed by any other person other than Leela Kumari? Because it's a sole proprietorship concern. Not done for a decade. This is where section 39 principle would apply. Then, another aspect, your Lordship can see, page 59. Is it not a thing which you are making us believe that your request for partnership is under consideration? It cannot be said that I have given it for Civil Supplies Corporation, I have given it for the Revenue Department. No, this is not proper explanation for this letter at all. Kindly permit me to read para 2 thereof. Look at page 59, 21/7/2010. This acquiescence by conduct is reinforced by this letter by the Indian Oil Corporation, which says the above agency was not managed well by Srimati Leela Kumari due to financial problems. She had paid the dues to IOC and wants to induct one K. Prabhakar as financial partner. Pause here for 1 minute. That this, with the complaint saying that from 2010 onwards I have been placing index, etc. Can the corporation plead total ignorance and say, I do not know anything about this? Then what do the next part? Based on her letter requesting us to induct K. Prabhakar as a partner, we are processing her request for induction of partner. Getting a question to myself, did the processing result in a negative reply? If so, where is it? The answer is no, they have not given it. And the reason which they say is, in one of the show cause notice and the personal hearing, you were aware. How does it become aware? When you make us feel that it is under processing, was the letter post 21/7/2010 issued by the corporation saying that we have processed your request, we rejected it? The answer is no. Therefore, the second submission would be ancillary, or a second submission would be, it is not by mere conduct, but by your letter also you are trying to say, we are processing and you have never finalized. Third crucial aspect would be, is after the clauses etc. are given, a reasoned order is passed is what I was heard to say. By a reasoned order, do we mean that we write 15 pages and be done with it? That's the quantum. People in the past used to give jokes, my lord. If you write 40 pages, you will pass. For 1 mark at least you will get 36, therefore pass being 36, write even Bro Cinema Story also you will get 40 pages is important. Are we going to be governed by that? The answer again can be known. Now, after 7 or 8 pages of the things which have been there, the only contribution, if I may say so, is painful extraction of the terms of contract. And this qualification that you have not given, etc., is not. And the third aspect to bring the entire thing is, we have given you an opportunity till 31st of October 2020. You have never failed the opportunity. Consequently, you have forfeited your right to reorganize or reconstitute your court. This is what my learned friends. Absurdity of that, if I may say so, with great respect to my learned friend, is this. Kindly see the letter which my learned friend read with lot of patience at page number 32. 22/10/2010 at page 36. This is how my learned friend started reading this and trying to put this against me. Yes. Page 36, my find along with their counter. Grateful to one thing. This is where divine justice intervenes once in a while. Kindly turn to page 37 for 1 moment. Moreover, this is one which is very, very relevant for our purpose to knock down her case. Magnanimous was here and projected. Not right. Yes. And magnanimity is not reflected in the action of the respondents below. Kindly see page number 37. Moreover, this is how the sentence begins. Moreover, by your letter dated 19/10/2020, wherein you have specifically mentioned that due to your son's medical condition, you have given power of attorney to K. Prabhakar for making all transactions pertaining to so and so. By letter dated 19/10/2020, you have requested us to continue the agency as proprietorship in your own name. That started and stopped with that paragraph. Now, what is that is being submitted is, next sentence is a complaint. The entire discussion is on a complaint, but why this cannot be considered as a request prior to 31/10/2020 is not dealt with in that order. Does the form matter or the material matter is not dealt with in that order? If you have prescribed a form, is it so mandatory that it has to be given only in that manner? Is one more thing. Now, by virtue of the letter dated 19/10/2020, what follows would be this. By mistake, someone has been there. Now that you have, enlightened me that you are not going to entertain a partner, please retain it in the same manner which it was available. Can this request be called out of the scheme which they are now trying to do it? Not recognize the scheme of the partnership at all means thereby it's a sole proprietorship also. Now, after this letter has been given on 19/10/2020, I am asking that please treat me only as a sole proprietor. Then where is the question of reconstitution, etc. at all? This should have been discussed in the letter. No, it doesn't do that. It continues with the complaint and says you are a person because that man said you are this person. How is this a relevant consideration at all? If you have dealt with saying that you have a big partnership, and I just put it like this manner. On 90, I mean in 2010, when a partnership was projected, you said it would be under consideration. If that was considered in my favor, perhaps the entire agreement will have to be redone, which did not take place, nor was a negative communication given to me. So therefore, we were thinking this is the situation which is going on. Coupled with the statement that for the past 10 years, Mr. Prabhakar was dealing with you, including placing intents, etc., returns, etc. It was made to believe that the system is right. Now you have given some opportunity for us to reconstitution of the entire agency. Now at this stage, I come to the conclusion because Prabhakar seems to be creating troubles, or I have been creating troubles to Prabhakar. We said we are bidding farewell to your partnership. And I come back to the IOCL saying that right now we have been working as a partner. Original agreement was only of a sole proprietor. Now treat me only as sole proprietor. Does that not warrant consideration at the hands of the IOCL? Was it considered? This letter does not talk in that language at all. So what happens is, this letter you have not availed may not be of any relevance. Now, the impugned order which has been passed, that is on the page 18. Refers to 22/10/2020 at page 26. It only refers to that. Even if you were not, sorry, page 26. It unnumbered paragraph about para 9. 4 lines or 5 lines from the top, your lordship should get this. Furthermore, you may kindly refer to the corporation policy prevailing. Furthermore, you may kindly refer to your submission made during the personal hearing at 18/8/2021.
You're referring to page 26 of the counter?
No, my lord. The impugned order, that is cancellation along with the reflection method. I'm sorry.
Yes.
4 lines from the top, it starts like this, madam. Furthermore, you may kindly refer to your submission made during the personal hearing dated 18/8/2021, where you have specifically stated that since you do not want to induct Sri Prabhakar into distributionship, you did not avail the option of giving our letter, given by letter dated 22/10/2020. Even if you are not willing to induct Sri Prabhakar as partner, you could have rectified your mistake by paying the ratification. Now, the 22/10/2020 letter talks of paying the ratification in spite of the fact that you have not, we have not recognized you as a partner. The 22/10/2000 letter does not talk in that language. It says you give your request. It does not talk about my request dated 19/10/2020, which is much before 31/10/2020. No, this they say that because you have not accepted the proposal. Actually, if there is no reconstitution as to what it was when the agreement was there and at that relevant point of time, making a question to myself, when should I find a ratification at all? The partnership you have never recognized. Partnership is not what I want right now. Then there is a question of myself asking for a ratification or a rectification or whatever it is of the constitution. What it was at the time of the constitution, I am saying let it continue at that. You shouldn't have any forms for that. This is not considered. And then single paragraph. Your actions will only find all the clauses which are said to be violated, and then they say this is the impact. And this is the best order according to my letter that I will pass. Then what would it must is anybody's guess.
Yes.
So therefore, summing up in reply, I only say 3 aspects. Number 1 is you were aware, you never bothered. Section 39 comes to my rescue. You made us believe that you are going to consider, you never gave a negative aspect. Therefore, it doesn't lie in your mouth to do. And third important aspect is the very complaint says I have been dealing with you, I have never denied it in any form. Finally, you use that tool itself to non-suit me in my humble submission, my lord, is not God. I place that one judgment, my lord, which says when you are now trying to downtrodden people or marginalized people, your attitude should be more magnanimous. Of course, that may be from an ex-serviceman's wife, which I gave and recommend. Not that it would have any precedence on your lordship, but at least this philosophy must, this philosophy comments itself for before my lords is what I could humbly say.
2010.
13 SEC by 760. That's maybe totally different. But the only thing is that that's a case where an armed forces, widow of an armed forces personnel was given an agency, similar facts of induction of a partner, removal, all these things that happen. The court said, my lord, you will have to consider it with a pinch of compassion because it's so and so. Now this is a case, my lord, where it is for a scheduled caste woman, exclusively for a scheduled caste woman, which you have given. And one last statement is, I have pleaded in my repetition, specifically saying, I approach the Indian Oil Corporation for an advice. Next sentence, perhaps I had no option but to do it. My amendment is reading as though we have forced. I mean, the petitioner was forced by the IOC. But perhaps that may not, if that is the understanding, perhaps that sentence is perhaps be a better different. But what we specifically said was, we approached the Indian Oil Corporation at para 4 of our affidavit. We said this. A bit guardedly burdened, but one step was beyond that. And the amendment is trying to take some advantage of it. Rightly so, perhaps from our side. Kindly see para 4 for a moment. What we did is say, it is submitted at the affidavit. It is submitted when I approached the IOC. The corporation advised me to add a partner to your business by taking financial assistance from him to clear the dues. Accordingly, though I am not interested, this is what I said. Forget the later part of it. I'm not going to, what is it trying to do it. Now the reply for this in the counter affidavit, please to certain extent, is liable to be read in my favor. Kindly see para number 11 and page 9 of the counter affidavit. Last 2 lines perhaps may come to mind at a certain extent, and please. Hello there. What they say, 2 lines from the bottom only, I read, my lord. In case any distributor approaches the corporation for any assistance or guidance pertaining to their distributorship, guidance as per applicable guidelines in vogue at the time is provided, and it is not specific only to the petitioner. Period. That is, we keep advising them. We don't force them. This is what they say. The language of the person says we have forced them, but it's an economic force which perhaps I can say, my lord. I have no alternative. 9 lakhs I will have to pay. The corporation is behind me. I mean, I will use it an expression very politely, my lord. Corporations, I will have to pay the dues of the corporation. I don't have money. The petitioner's son is just spastic or some problem. So she had to pay money to retain her livelihood. So she went and approached them. A suggestion was put forth, no arm twisting from their side, but that suggestion was acted upon. You were also happy with it for 10 years. Now termination is back. That's the long and short of my submission, Miller. And section, since it's a contractual matter, section 39 definitely must come to my responsibility.
Kindly see paragraph 10, page 11 of the contract.
But for the answer, technically there will not be a reply.
Having I don't use it, having judgment for that.
Yes, ma'am. Yes. The learned senior counsel, Mr. Sudha, the learned counsel for the respondent, mentioned that the same caption on 14.